Wait, Peter.
Yes.
Hello, item number 41. Already there is a order to upgrade. May I upgrade it? Man, can be at 2 o'clock. Man.
There's an order for upgrading. It will be done.
Man.
May I please order? Lordship, may item number 54. Lordship, this matter relating to non-payment of return benefit of the corporation. Lordship, yesterday's personal affairs matter. Lordship. And this matter was also taken up on 10th of May. Lordship, along with other matters.
For that matter?
Yes, Lordship.
The plain tribe.
Yes, Lordship.
Item number 54.
54, Lordship.
Let this matter be listed along with WPC number
5636 of 16.
of so and so on 10/5/2023.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention for orders, listing for order, Lordship, WPC 4122 of 2021, Lordship.
Why?
So on last date, it could not be reached, Lordship. It's an urgent matter.
What is the urgency?
Lordship, it is a non-payment of arrears salary, Lordship.
Since
2000, it's from the period of 1/07/1998 to 02/03/2005, Lordship.
2005. We'll have it on 10th of May.
May please, Your Lordship.
And you mentioned the matter on that day for upgrading.
May please, Your Lordship. Lordship, in item number 17, I filed an affidavit. Lordship, there needs to be some correction. Lordship, can I be allowed to make those corrections?
I am mentioning 17, Lordship. It may be come up on next week. If advice, I will file
Reply.
Which one?
17, same matter. I am for the petition.
Mr. D. Upamanu, the learned counsel appearing for
Health Department.
Health Department submits that he has filed an affidavit. Here, that the Health Department has filed an affidavit. Mr.
A.U. Ahmed.
A.U. Ahmed, representing the petitioner, submits that he would like to file a reply.
If advice, I need to go through it. Otherwise, it will cover.
Reply. If so advised. No, he submits that as the affidavit has been served today.
No, Lordship, on
today,
21st, I
but
filed.
I received it from my colleague today. If
As the affidavit is yet to be, the contents of the affidavit is yet to be communicated to the petitioner. A week's time may be granted so that if so advised, he may file a reply. Which lists the matter again on 23rd of the 22nd of May.
Highly obliged.
Yes, please, Your Lordship. Your Lordship, this matter may be listed for motion on 3rd May.
Why?
The urgent matter, this matter relates to compensate appointment.
Oh, yesterday you mentioned it. That is the thing.
Yes. For 3rd May.
Huh?
For 3rd May, listing for 3rd May.
3rd of May.
Obliged.
Please, Your Lordship, I beg to mention WBC 62/7/2022 is for order.
Why?
Lordship, last date it is not reached.
That's good. But why is it necessary?
Lordship,
It will otherwise come.
Lordship, it is delay of payment.
Okay, we'll have it on 17th of May.
Please, Lordship. On item number 23, Lordship. I'm on behalf of J. Roy. Due to some personal difficulties, he would not be.
23. At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks. You are the petitioner?
Yes.
You are the petitioner?
Yes, Lordship.
Daily list item number 1 for withdrawal.
I'm praying for withdrawal because the petitioner has already got relief.
You got the relief.
My lord.
Mr. M. Khan, the learned counsel, appears on behalf of the petitioner. Ms. D. Musairi appears on behalf of the Secondary Education Department, and Mr. A. Solia appears on behalf of the Finance Department. The learned counsel for the petitioner submits that he has already got the relief sought for in the petition, for which he seeks to withdraw the instant petition. Accordingly, the instant petition stands closed on becoming infructuous.
Item number 2 for withdrawal.
Same lordship.
Same order, same party.
No, different case, but in this case also.
No, same parties.
No lordship.
Now this is elementary. You are appearing for elementary also?
No.
Mr. P. N. Sharma, naam to bhai dito. And Mr. A. Solia appears for the Finance Department. And Mr. J.K. Goswami appears for the Director of Pension. Pension?
My lord, this is relating to pension lordship.
Pension.
My lord.
He appears for whom? Mr. Goswami, you are appearing
I'm
for?
appearing on the respondent 3 lordship.
What is that?
The director of pension.
That is what I said.
Yes.
Mr. J.K. Goswami appears on behalf of the Director of Pension. The learned counsel for the petitioner submits that he has already got the relief, and as such, the petitioner does not wish to further proceed with the instant petition. Accordingly, the petition stands closed as it has become infructuous.
Item number 3 for withdrawal.
Yes. What is this withdrawal business?
Actually, your lordship,
Oh, that matter.
that matter, yes. Mother,
Mother, I gave that only opportunity. Some opportunity I've given. Na?
is 13 years.
Instant petition stands disposed of, thereby granting liberty to
Yes,
the party approach the appropriate forum, claiming maintenance in terms of the above quoted.
Second day approach.
But Mr. S.A. Islam,
Yes, system. Yes, system.
S. Islam, the learned counsel for the review petitioner, Mr. R. Ahmed appears for Accountant General.
Accountant.
Appears for the Accountant General. Mr. A. Solia appears on behalf of the
Finance department.
Finance Department. And which is the concerned department?
Higher education.
Higher Education. Very deep. Mr. D. Upamanyu was here. Mr. D. Upamanyu appears for the Higher Education Department. So the learned counsel for the petitioner submits that he would not like to press the instant review petition. Accordingly, the review petition stands dismissed on withdrawal.
Blessed.
Item number 4 for motion.
Yes, Mr. Rahman.
May I please, Your Lordship? First, this matter relates to discharge from service, my lord. The petitioner was the LDA of Amguri Municipal Board.
Why you have been discharged from service?
My lord, the allegation was misappropriation of money. But my lord,
So inquiry held?
no, without inquiry. That is my point.
Oh,
Without any inquiry. And against that, my lord, I made an appeal before the state government as per provision of the Act.
understood. I am only thinking, should I allow the petition today itself?
Lordship, the respondent number 3 lordship, the municipal board, we are not appearing on behalf of respondent number 3 lordship.
Okay. But who,
One,
he was
2, and
working
4.
in this respondent number 3 municipal board.
Yes.
And whether the provisions out there apply for the discipline and appeal rules?
Yes, because their service rule is not there. Only draft stage, but that is also not applicable. They are using this disciplinary rule.
So you are claiming right under 311?
Yes. And that was considered by the state government also. That is an annexary, page 60 and 60.
What does the state government say?
Like,
Where is it? Page
Page 60, annex 11.
60. With reference to the United 50 of the Iman governs the matter of establishment of an
As per
Request
in-
to take necessary regarding the reinstatement of so and so from your end as per section so and however the judgment and order of demand relating to the matter be complied. So the government has given in your favor,
yes, then second director, page 61 also. Director is also specifically written for reinstatement.
but they are not doing it.
Yes, yes.
So then we have petition. Heard Mr. H. Rahman, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent number 1 and 2.
2 and 4, Lordship.
1, 2, and 4. Issue notice making it returnable on this is what date? 28th. Na? Issue notice making it returnable on 31st of May 2023. As Mr. J.K. Goswami, the learned counsel appears on behalf of the respondent number 1, 2, and 4. Extra copies of the petition be served upon him by 2nd of May. As regards the respondent number 3, steps be taken by way of registered as well as usual by 2nd of May. The petitioner further, you want the matter to be disposed of early?
Yes, ma'am.
Take justice service.
Yes, yes, that will be.
The petitioner is also directed to take justice service upon the respondent number 3 routed through the registry of this court and file an affidavit of service on or before the next date.
Lordship, may it fix on 3, Lordship, 3 or 4, any date.
June?
Yes, June.
Why?
31st, there is some difficulties.
Anybody else can?
Lordship, no,
Because here you have, there is nothing to do. It is only this Amguri.
yes, Lordship.
Yes.
The municipal board, Lordship.
You want to have it on 3rd? You can have it on 3rd is Sunday. Saturday you want to work? We'll have it on 2nd of June.
Lordship.
2nd of June.
Yes. No, the subsistence allowance is still pending, my lord.
We'll see on that day.
Yes.
The case of the petitioner herein is that the petitioner was discharged from his service by the respondent, by the officials of, by the respondent number 3 in contrary to the provisions of Article 311 of the Constitution, as well as the provisions of the Assam Service like a Discipline and Appeal Rules 1964
And also, my lord, Assam Municipal Act Section 50.
and Section 50 of the Assam Municipal Act 1956. It is the further case of the petitioner that the petitioner had preferred an appeal against the order of discharge before the director of
Before the government, ma'am.
before the government. And the government had also directed that the petitioner be reinstated by an order dated
26 February 2021. Page 60, ma'am.
26/10/2021.
26 February, ma'am.
26/2/2021. And further, no, full stop. In pursuance thereto, the Director of Municipal Administration had also directed by another order dated 26/10/2021 for reinstatement of the petition. But till date, the respondent number 3 have not acted upon them, upon the said orders, for which the instant petition has been filed. The respondent number 3 is directed to apprise this court as to why the petitioner have not been reinstated pursuant to the orders being passed by the government, as well as the Director of Municipal Administration, as above noted. Further to that, the respondent number 3 shall also apprise this court on the next date as to whether a person can be discharged without holding an inquiry, as is otherwise the mandate of Article 311 of the Constitution and the Assam and Assam Service
Discipline appeal.
Discipline and Appeal Rules 1964. Liberty is given to the petitioner to mention the matter for upgrading.
I,
Yes, Mr. Singh.
Petitioner is a retired government employee, my lord. When he was serving as the block elementary education officer of Sonari, he was placed under suspension. Page 24. After 4 months of suspension, nothing has happened, and accordingly, I submitted an application for my reinstatement. And accordingly, I was reinstated in service after 2 years. Page 31. From page 31, 32 onwards, the departmental authorities has requested each other for regulation of my service during the suspension period. But till that suspension period has not been regularized.
Regularizing the period of
Yes,
suspension.
my lord.
Okay, then.
And I have also not received the remaining amount of subsistence allowance during 2 years. 50% for 3 months and 25.
You have not got any subsistence allowance?
During that period, I have received 50% and remaining amount.
So you have area.
Area.
But first there has to be a regularization.
Yes, my lord.
That has not been done.
That not been done.
And what has happened till now as regards the disciplinary proceeding?
Nothing has been done, my lord.
And what has happened to the police case?
That is also not. I have not received any charge memo, no notice.
No charge sheet?
No, my lord. And accordingly, the government has requested the director, page 46,
You are retired?
on 39/2021.
Yes.
Page
What is the
46.
government asking for? In inviting subject,
Yes.
I would like to request to take necessary steps for grant of provisional pension in respect of so and so. You have not got your provisional pension
I
also?
have got the provisional pension, my lord, but page 46, being appointing authority, the director was directed to authorize to take necessary steps regarding regulation of suspension period.
I'm here to
on the
return here
basis
with
of
the
outcome of
proposals for
DP.
regularization of suspension demand following instruction.
Clause
So
2,
you are hereby authorized to take necessary steps regarding regularization of the demand as well. With regard, you are also requested to take steps action for sanction of the demand. Now, you have got your provisional pension.
I have got the provisional pension.
Sanction is given to rupees 25,000 plus other balances to so and so who have retired from so and so for payment of provisional pension. Now you have got it.
Yes.
Now only problem now is your regularization of
Yes,
that
sir.
period and for area salary.
Yes, madam.
That is the only claim.
Paragraph 21, I have received the GPF amount in my petition.
Very well. Have you got the DCRG? No.
No, my lord. I have received the GPF,
Now,
GIS.
what is your prayer? A writ of mandamus directing to regularize.
Yes, ma'am.
Writ in the nature of NAIA to release the admissible service benefits like gratuity, 2 increments with time scale of pay, promotional benefit, finalize the pay. Oh, you have not got the regular pension.
Yes, ma'am. No,
Now, what is the status of the case?
my lord, I have not received anything. my
No,
lord.
no, you have not received. There is an FIR being filed against you.
Yes, madam.
You must be knowing what has happened to the
My
FIR.
lord, then, my lord, show cause was issued. I have replied the show cause.
Forget about the show cause. FIR. What has happened?
I have no idea, my lord.
Is there an FIR filed against you or not?
Not, I have not received anything.
No, why you were suspended? Let us see your suspension order.
My lord, page 24.
Whereas an amount of so and so from the treasury office of so and so is so and so and disburse the area of so and so. The undersigned, therefore, the man who was holding the post of AIA is deemed to have been suspended pending the evidence against the salary of the year due on rotation under the PO. Why he has been deemed to be suspended?
My lord, on the basis of some newspaper
Without
publication.
prior permission of the authority. Now, what has happened out here?
My lord, I have been reinstated.
Then there was a show cause issued.
I have replied the show cause.
You have given your reply.
Page 26. Then,
So there is a charge sheet given to you.
no, my lord.
Obviously, why you are replying and saying that in reply to charge number 6 of your show cause notice
Well, they
dated
have-
so and so I have
The
denied.
show cause.
Then
After,
the show cause has been issued that the departmental proceedings have been initiated.
my lord,
Then why you are saying no?
my lord, paragraph 22.
Why haven't you enclosed the show cause notice
My lord, paragraph 22.
of
paragraph 22 of my writ petition.
No. I only go as per the documents. Look into your paragraph 22 later on.
My lord,
There is a show cause notice or a proceedings under 9.1 have been initiated against you, 9.2. Otherwise, why would this reply come at page 26?
yes, my lord. After my
Your show cause notice dated 1/10/2013. So there is a show cause notice.
my lord,
See? And then after this, you have replied. What has happened thereafter?
we have a page
Then
21.
subject to the outcome of the findings of the police investigation and perusal of the inquiry report submitted by the inquiry officer, meaning thereby the inquiry has started
Yes.
and there is already an inquiry officer who have been appointed.
Yes, my lord.
So there is a disciplinary proceeding. What happened there?
Thereafter, I have not received anything, my lord, from the date of
Have
reinstatement.
you must have appeared before the inquiry committee.
They have not invited me, my lord. No notice has been issued.
You have accepted this order, and on the basis of this in 2015 you have been reinstated, and now you say that you don't know a head or tail about what has inquiry has happened.
I have-
You have to be clear, Mr. Counsel.
Yes, my lord. I have not received anything, my lord, regarding the shop.
How can there be a regularization of your service if there is already a punishment imposed upon you? Issue notice only.
Yes.
Or Mr.
I'm sorry.
But Mr. Counsel, next time onwards, be more clear on your facts.
Yes.
It is not apparent, isn't it, Mr. Sharma?
Lord.
Although I don't read the brief, but then also it is apparent from this.
Lord.
Heard Mr. N. Hussain, the learned counsel, appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the
All the respondents, Lordship. 1, 2, and
Elementary Education Department. Appears on behalf of the respondent number 1 to 4. The issue notice making it returnable on 7th of June 2023. As Mr. P. N. Sharma accepts notice on behalf of the respondent number 1 to 4, extra copies of the writ petition be served upon him by 2nd of May 2023. The case of the petitioner herein is that the petitioner was put under suspension on 3rd of December 2012. Thereupon, it appears from a perusal of the materials on record that there was a memorandum, there was an initiation of a departmental proceedings by issuance of a memorandum of charge against the petitioner, in as much as the petitioner had submitted a reply on 30th of April 2000, had submitted a reply on 29/11/2013. It further appears that there was some inquiry officer appointed in as much as a perusal of the order dated 3/12/2014 by which the petitioner was reinstated. Mentions about a pending police investigation as well as an inquiry to be report to be submitted by the inquiry officer. However, it appears from the records that the petitioner has been persistently pursuing with the respondent authorities as regards the regularization of his suspension period, as well as for payment of the arrears salary during this period of suspension, after deducting the subsistence allowance which the petitioner have already received. It further transpires from the records also that the petitioner have also claimed that further appears from the records that the petitioner is presently getting his provisional pension, but however the other retirement benefits to which the petitioner claims to be entitled to have not been given to him. It is under such circumstances that the instant writ petition has been filed. The learned counsel appearing on behalf of the respondents shall apprise this court on the next returnable date as to as regards the fate of the inquiry proceedings which was departmental inquiry proceeding which was initiated against the petitioner, and as to whether there has been any police case. on the basis of the allegations so made in the show cause notice issued on 1/10/2013. 1/10/2013. Full stop. Further to that, this court, the respondent authority shall also apprise this court that if as to what steps have been taken pursuant to the order, pursuant to the communication issued by the Undersecretary to the Government of Assam Elementary Education Department to the Director of Elementary Education Department on 28th of July 2022, as regards the regularization of the services of the regularization of the period of suspension.
Six.
Yes.
So here the petitioner is praying for pay parity with that of the other counterparts working on a regular basis. The petitioner was appointed in the 1995 as a LDA post, working as a typist cum clerk cum typist.
You are asking for pay parity with whom?
With the other counterparts drawing the regular salary, the LDA cum typist employees working in the social welfare department. They are drawing salary at a higher scale. I am only getting 9,000 per month since 1995. I was appointed in the 1995 on temporary basis. My appointment was
You were appointed as what? LDA?
LDA cum typist.
Oh, you are on this Jagjit Singh business, where the temporary person also is entitled to the minimum of the scale of pay.
Exactly, madam.
And the government finance will say that in view of that judgment in Upendas,
Yes.
it is only till that particular period is 10 years from that period. Isn't that your stand?
So the Upendas is also very clear, relied on Jagjit Singh case.
Understood. I know that. Read that judgment many, many times.
Yes.
So there it has been mentioned in the penultimate paragraph that any casual employee is entitled to the minimum of the scale of pay.
Yes.
But do you come within these 10 years?
Yes, I come within the 10 years. I have been working since 1995. My appointment has been continued.
So 10 years from 1/8/2017.
Yes.
So therefore you are entitled.
Not from 1/8/2017.
That the judgment is says about from 1/8/2017. The penultimate paragraph 22 or paragraph 23.
52.
What does it say?
If I may read, my lord.
Yes.
Last paragraph.
Read the last portion.
It is, however, heartening to learn that the state government has agreed not to terminate the muster roll workers and similarly placed employees working since last more than 10 years, not in sanctioned posts, till their normal retirement, except on disciplinary ground or on ground of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as welfare measures for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in the light of decision of the Supreme Court in the state of Punjab versus Jagjit Singh, also direct the state government to pay minimum of the pay scale to muster roll workers, work charge workers, and similarly placed employees working since last more than 10 years, not in sanctioned posts with effect from 1/8/2017.
That is what. 1/8/2017. You come within the
Continued from 1/8/2017. I have completed 6 years, but I was given the officiating function since the year 2011. If I may take your lordship to page 40.
Yes, where?
In the interest of public service and smooth functioning of social welfare program, page 40, 40.
40?
40.
40. Okay. You are Mamta Rani Dey. You approached this court earlier.
Yes.
Earlier, my lord, when I was not giving the minimum of the wages. And
then what happened?
The learned court directed the authorities to consider my prayer to pay me the minimum wages, and subsequently I was granted. Now 9,000 I am drawing per month as a minimum wage from the department.
Then you want pay parity or minimum of the wage?
Pay parity, my lord.
You want pay parity. Pay parity with the regular persons who are working as LDA.
Same board.
Same post. So this is comes under Jagjit Singh.
Yes.
Yes, Mr. Singh.
My lord, what happened, my lord? The petitioner initially was engaged in a grade 3 post temporary for 2 months, 2 months extended, initially appointed 30th March 2095. And they are extended up to 1999 by the Social Welfare Department. And thereafter, I don't know, his service may be grabbed. And page 40 is, my lord, the appointment issued by the Deputy Commissioner. Deputy Commissioner, my lord, issued on 28 February 2021. So this case is not covered by this, my lord,
Upendar.
Upendar.
No,
He is not
Upendar said
continuing.
it is okay, but he is claiming that the same person, as he is working in the same post,
No, my lord.
exercising the same functions. But how are you appointed?
It was appointed by the director. My lord,
How?
office.
Director of Social
Backdoor
Welfare.
entry.
Huh?
Backdoor entry. I was not
Now, if it
appointed.
is a backdoor entry, can you claim pay parity?
That's what held in the Jagdish Singh case.
No,
Because-
Jagjit Singh has been done, but Jagjit Singh did not take into consideration two constitution bench judgment, and that is why subsequently by another two judges bench of Justice Lalit and I think they have categorically held that the manner in which a person has been recruited has also to be taken note of. Now, if you have not been recruited in a proper manner, can you be entitled to the minimum of the scale of pay?
That's where the distinction drawn in the Umadevi's case, paragraph 53, regular appointment and irregular appointment. The person who didn't have the exact qualification for the
No,
post.
Uma Devi is a case of irregular and illegal.
Yes, my lord.
You come within the ambit of illegal.
Irregular, my lord.
No, illegal. How can you be irregular? You yourself admit that it is backdoor.
There is no selection.
Irregular would be something where there were posts were limited to that effect, but then also by way of a selection proceedings, this has been done. Thereby, there is no violation of Article 14 and 16.
But my lord, I have been working in the sanction post in the year 2011 when I have been allotted the post of LDA cum typee. There is a sanction post. My lord. I have been working till today in the sanction post.
Understood, you are appointed to a sanctioned post without following a due process. Does it legitimize your
It doesn't legitimize my
appointment?
my lord. As
Then
per
under
Umadevi's,
such
but so far as-
circumstances, how can you say that you are entitled to the same pay with a person who have been duly selected?
But that's where the Jagdish Singh come, my lord. It take into consideration.
Jagjit Singh was there, but thereafter there is the other judgment which has come subsequently, 2018-19 SSC.
Upendar's.
But my lord, so far as Jagdish Singh case is concerned, it has not been overruled. The
That has been clarified in the judgment that Jagjit Singh did not take into consideration these aspects. That was a case where there were two sets of teachers in the same school doing same work. Even they were also given the work of a principal, some Ujala scheme or something, I forgot the name. This is also a case of Punjab. Everything was done the same. But the question is, the recruitment was made separately. One was made under a scheme and the other was made under another. Then it was said that Jagjit Singh took into consideration everything, right from A to Z. But however, did not take into consideration two important constitution bench judgments where the Supreme Court had categorically seen that the source of recruitment is also one of the parameters to be looked into for the purpose of pay parity. And worst of all, 3 days back, another judgment has come against you.
Your Lordship, for us, discussing about the Niyal Singh judgment passed in Punjab High Court, which was ultimately upheld by the Supreme Court, where the PSOs were appointed under an act. And so the distinction was drawn by the Honorable Supreme Court that the person appointed under an act and the person who is otherwise appointed are two different set of persons. So they were allowed to be regularized. So that was a case of regularization.
No, this is not a case of regularization which I am referring to. It's a pure and simple case of pay parity. Look into the judgment. But anyways, I'll issue notice just for the sake of it. Don't get anything. Although there is one other case which I was dealing with, I don't know where the matter has gone, by Mr. I.H. Saikia, pertaining to those foreigners tribunals where there is an appointment. Mr. Goswami, you are there, na? What happened to that matter? I don't see it nowadays in my. Okay, here in this court. Okay, so that matter is another matter where it seems to be similar to this. These people were appointed, they don't come within the ambit of Upendas, but they are appointed on a particular date after, in view of this new, all these new foreigners tribunal has come in. Na?
Yes.
Earlier they were a foreigner tribunal, these were the stenographers who were there. And thereafter, these are another set of stenographers. They are doing everything, but they were appointed after these new foreigners tribunals have been constituted. So they are claiming the same because they are doing the same work. Although they didn't come within the ambit of Upendas, but otherwise they come within, in view of Jagjit Singh, they are entitled to. But here you have a problem with your recruitment in view of that 2018-19 SCC. Anyways, heard Mr. S. Biswas, the learned counsel, appearing on behalf of the petitioner. Mr.
I am for response 2 and 3.
Mr. T.C. Suti appears on behalf of the respondent number 2 and 3. And Mr. A. Solia appears for the respondent number 1. You should notice making it returnable. When are you filing your affidavit?
Yes.
How much? Because this is a case of filing affidavit, no instruction business.
4 weeks.
4 weeks. You should notice making it returnable on 7th of June, 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 2nd of May, 2023. The issue involved herein is that the petitioner herein who has been appointed on temporary basis as an LDA in the office of LDA cum typist in the office of the Child Development Project Officer. The petitioner claims pay parity with those LDA cum typists who are also appointed in the office of the Child Development Project Officer, but on regular basis. The respondent shall file the affidavit by 2nd of June. Petitioner, if so advised, may file their reply by 7th of June.
Item number 7.
You are 56 years. Eh?
Yes, my lord.
I hope your matter finishes up before that.
Hopefully, my lord.
Yes, Mr. Ali.
May I please, Lordship? Lordship, petition pertaining to Lordship financial benefit for acquiring B.Ed degree, Lordship. Lordship, B.Ed degree, Lordship.
Oh, that one, same.
Yes, Lordship. Lordship, I am relying on page 68, Lordship, and it's 13, Lordship. Your judgment, Lordship.
Same.
Lordship.
Disposed of.
Lordship.
And you are appearing for BTC. And so BTC, oh yeah, it order to Yapa side. And how many inspector of schools are there?
Lordship,
Seeing from the court fees, it seems there are many inspector of schools.
one, Lordship, Udalguri.
Ito get change to Kali Udalguri. Ito a paragraph number 2 and 3 is not necessary. 2, 3, 4, 5 is not necessary. Huh? Mr. Itu Tiatipo, S. Ali, D. Musairi, and Mr. So-and-so appears on behalf of the BTC. BTC. Bagi kini, 6 of 6 or 10 is same. Kali hit 7 or 8 or 4, 5, 6 no kori. Our inspector of school is respondent number 4.
Lordship.
5, 6 nalag.
8 similar, your lord. 8 is also similar.
8 is.
Similar. Inspectors are there, 3 inspectors.
3 inspector is there, Lordship. Moshalpur, Tirang and Borpeta.
Court fee paid.
Lordship, yes, Lordship. I have it. With the
Obligely.
Item 9.
Yes, Mr. Sheikh.
Please, Your Lordship. I was appointed as Gram Sevak in 1984 and continued to serve up to 1996. Thereafter, my lord, I developed mental disorder and I was under treatment. And thereafter, my lord, in 2005, again I joined, and for 3 years I continued 2008. And thereafter, my lord, again disorder started, my lord. I retired in 1996.
You retired on
1996.
and you have not got your pension?
No, my lord. No pension has been given. And another thing is this, my lord. No departmental proceeding against me. I was not discharged from service. So I was in continuous service.
So
I
you
was-
retired?
Yes, my lord. I retired.
You issued a superannuation notice?
No.
Did you submit any papers for pension during your service?
No, my lord. I filed representation. They did not concern that representation also. They are not addressing that
Is
representation.
your service pensionable?
Yes, my lord. Pensionable. It's a regular service. I was regularized, my lord. I filed 2 representations, my lord. They did not attend that. So, my lord, total I have given 16 years of service.
As
My lord, at Gram Sevak in different development blocks.
Gram Sevak.
Yes, my lord.
What is this Gram Sevak? What do they do?
My lord, they used to advise the agricultural people, my lord. They visit the village, agricultural advice, etc.
They?
Agricultural level, my lord. They used to visit the villages, give advice to the local area, my lord, regarding agriculture, the manure, etc. Till date, my lord, post Gram Sevak is there.
What is you retired on
1996,
19?
96,
1993?
96, man.
96. And what were you doing all this while?
So my
How
grievance
can you
is
retire in 1996? Can you see page 24? I have the honor to inform that I have joined my duty at 10 a.m. This is of 26/8/1998.
20. Your lordship referred to page
4.
24.
And again you are joining
My lord,
in
in
2000.
that case, my lord, retirement date I'm sorry, my lord, in 2016.
That is what.
Yes, my lord.
I have the informed that I have joined my duty. Why are you every time joining?
Because, my lord, mental disorder, again treatment, and again I approach. And thereafter, what happened?
And you
my
were
lord?
allowed to join.
Yes, my lord, thereafter I joined, my lord, in 2005.
That
And your lordship, joint director, directed to allow me to join, my lord. That is at page 30.
So as on 7/9/2020, you were mentally fit.
Yes, my lord.
Fantastic. When is it
And,
a
from
document that
7/9
you were not mentally fit?
7/9/2020, my lord.
Ah,
7/9/2020, my lord. I am claiming this. After I am fit, mentally fit, my lord, I approach the authority that service benefit pension may be given to me. But they are
so
not
from
giving.
2016,
My lord,
You are not mentally fit.
Not fit.
Then where is your document? Any medical certificate to the
Medical
effect that you were
certificate,
not
my lord,
fit?
I have given
Except
some medical certificate, my lord.
yes, Guwahati medical certificate. This is a certificate from
GMC
chewing and
thereafter
little nut
also, my lord.
inside. No,
Medical
Guwahati
certificate I
medical
have given, my
certificate.
lord.
Nervous disorder.
My lord.
Nervous disorder.
Now,
What
now
does it
your
have to
lordship
do
would be
with all
pleased to
this
see
thing?
Annexure 10.
Annexure
Annexure 10, page 31, 32.
so and so MS on detected so and so.
31,
He is
32.
Annexure 10 you are it gives a certificate that you are fantastic. Yes.
My lord.
On detected history
It is the
plus
medical
MSc
certificate.
finding, he is not found to be suffering from any psychotic disorder
At that
and
time,
he is found to be mentally fit at present.
my lord.
Where is the certificate that you were not mentally fit?
My lord, my medical certificate, first one, my lord.
At Annexure 5,
Yes, my lord.
that is nervous disorder.
My lord.
Nervous disorder is different.
My lord.
It can't be.
Find your lordship say nervous disorder, nervous related to brain, my lord. I do not know, my lord. And we are not aware about this medical thing, my lord. But thing is this, my lord, I could not
No,
continue.
we are
with
not aware, but we know our basic things
My lord,
also. Na?
my humble submission before your lordship, if your lordship take my service from 84 to 96, then 10 years, 13 years I have completed, my lord. And after rejoining also, my lord,
First of all, whether you were issued a superannuation notice,
no, nothing has been done by the government.
then how do you know that you have retired
My lord, that is
or
why,
you
my
have
lord,
retired by yourself?
that is why, my lord, government.
Do you have a service book?
My lord,
Do you have a service book?
I did not have.
You don't have a service book also.
My humble submission before your
Okay,
lordship.
show me your appointment order.
Yes, the appointment order.
Where is it?
My lord, appointment order, your lordship will be pleased to see page 16.
Page?
16 to 20.
A provisionally appointed temporarily subject to verification of they will join against the respective blocks shown as so and so. They are appointed in the scale of pay and so and so. The candidates have to produce one survey of permanent residence and so and so. Is provisional subject to so and so. This was in 83.
My lord, in 1994, my lord, I was transferred to Rongzuli Development Block.
Integrated rural development and so is and so successfully attended completed training. You are outdoor patient. I have the honor to inform you that I have joined. Hello?
Lordship in Annexure
So,
3.
my lord, my humble submission before your lordship,
Yes.
only thing, everything can be said. Whether I am regularized, my lord, whether my service book was opened, everything, my lord. As a government servant, my lord, it is the duty of the department to know everything regarding me. No departmental proceeding. I was not suspended. I was not removed from service. So what will happen to me?
No, you were temporarily appointed. You could have that was maybe
I was
been.
temporarily appointed. Whether
When?
my claim is this, I was regularized. my lord.
Huh?
I was regularized. And
When?
I was regularized, my lord. That
When?
I do not have service book, my lord.
Then?
That is my contention. I was regularized. Let the government say that I was not regularized. But after all, I was appointed. I am a government servant.
You don't become a government servant by just being appointed in 1983 to that effect unless you show something to that effect that there is a superannuation
My
notice.
lord,
You are asking for a pension.
Your lordship would be pleased to see. From
No,
90
Mr. Sheikh, there's no worry. I'm issuing a notice
My
only.
lord, my lord.
Nothing more than that.
My lord,
Don't expect.
yes. Notice will do. Let them say what happened to me.
Mr.
Whether I am
M.A.
a
Sheikh,
government
the
servant,
learned
I
counsel
serve to
appearing
them or
on
not.
behalf of the petitioner. Miss, Madam, you are appearing for?
N. Bora, for the respondent number 1, 2, 7, 8, and 9.
N.
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 Miss N. Bora appears on behalf of the respondent number 1 to 7. Huh? Oh, no, 1 to, oh, no, you are appearing for 1
2,
to
7, 8, 9.
1 to 7, 8, and 9. Mr. J.K. Goswami appears for the respondent number 3 and 6. Accountant General, we saw Mr. Hassan is there. Mr. A. Hassan appears on behalf of the respondent number 5 Mr. A. Solia appears for respondent number 4. Issue notice making it returnable on 9th of June 2023. Steps be taken. As the respondents are duly represented, extra copies of the writ petition be served by 2nd of May 2023. The instant writ petition has been filed by the petitioner claiming pension as well as the pensionary benefits. The learned counsel appear, the respondents are directed to file their affidavits in response to the instant as regards the claim made by the petitioner by 5th of June. The registry shall also indicate the name of Mr. A. Hassan representing the Office of the Accountant Generally.
Then
Mayor, your lordship.
Yes.
Relation, not bringing the departmental proceeding to his logical conclusion even after 2.5 years, and also non-payment of subsidy allowance for
Directing the
About
to
1
immediately make payment of the area subsistence allowance to the
Yes.
petitioner for the period concerned along with adequate interest and compensation. To bring the department against the petitioner to a logical conclusion within a stipulated period. Hello. You have not got your subsistence allowance till now?
for some period. There is area, your lordship.
Huh?
On June 21, I was placed under suspension on 29/10/2020.
Hmm.
I have been paid subsidy allowance for some period, but from June 21 till my date of reinstatement, that is about 1 year, I have not been paid the subsidy allowance in spite
Not
of
a single penny.
not a single penny. And
You are
your
entitled
lordship,
to 75%.
yes,
Okay. And now what has happened to the departmental inquiry? It is going on.
Show cause was issued on 17/2/2022. I submitted my reply on 23/3/2022. Thereafter, till then, no inquiry officer has yet been appointed. Your lordship.
You
And
don't
there
want to
is a
hold the inquiry?
Central Vigilance Commission circular.
Forest? Forest, na? Fantastic. Mr.
R. Majumdar.
I am Majumdar, the learned counsel appearing on behalf of the petitioner, Mr. S.M. Hassan, appears on behalf of the respondent numbers 1, 2, and 3. Issue notice making it returnable on, we have it early.
Yes, your lordship.
We'll have it on 24th of May. Get your instructions. I only want the instructions. Issue notice making it returnable on 24th of May. As the respondents are duly represented by Mr. S.M. Hassan, the learned counsel, extra copies of the writ petition be served upon him during the course of the day. We give it today. The case of the petitioner herein is that the petitioner was put under suspension on
By order dated 29/10/2020 with effect from 5/10/2020. Annexure 2.
Annexure 2 was put under suspension by an order dated 4. This is it?
No, 20. Annexure 2, page.
Or
29.
by an order dated 29/10/2020.
Yes.
Subsequent thereto, a departmental proceedings was initiated by issuing a show cause notice upon the petitioner. The petitioner replied to the said show cause notice on
23/3/2022.
23
3,
2022.
23/3 March.
3
23rd March
2022.
22. I'm going to return.
However, it is the case of the petitioner that thereupon, even after a lapse of 1 year,
More than one.
the responding authorities have not appointed any inquiry officer. And thereby, no, inquiry officer, to the prejudice of the petitioner. In as much as the petitioner is going to retire in
January 2024.
January 2024.
And further, your lordship, may I interrupt your lordship? Further, there is a promotion due, your lordship. My juniors have been promoted only due to pendency of this.
It is further the case of the petitioner that the delay in finalization of the departmental proceedings have led to the juniors having been promoted, and thereby the petitioner have not, the petitioner have been deprived. The petitioner further submits, it is the further case of the petitioner that although for a particular period, the petitioner have been paid the subsistence allowance, but there was no subsistence allowance paid for the period from 1/6/2021 to 18/5/2022, to which the petitioner is entitled to under FR 53 of the FR and SR as applicable to the state of Assam. Being aggrieved, the petitioner has approached this court. The learned counsel appearing on behalf of the Forest Department shall apprise this court on the next occasion, on the next date, as to what is the stage of the departmental proceedings so initiated against the petitioner, and when it is likely to be completed. Further to that, the learned counsel shall also apprise this court as to why the area subsistence allowance for the period from 1/6/2021 to 18/5/2022 have not been paid to the petitioner as claimed in the writ petition. Liberty is given to the petitioner to mention the matter for upgrading on the next.
Much obliged.
11,
Yes, your name?
AHMR Chaudhary.
AHMR Chaudhary. Full name?
Abul Hakam Muhammad Ridwan Chaudhary.
Fantastic. Now tell me, what is your case?
My lord, petitioner was appointed as Asha, my lord,
Oh,
on 20/11/2006.
it is within the domain of Mr. T.C. Sutia. Asha workers.
Workers, yes, the health department.
Yes, what do you want?
Case is petitioner, my lord. She is Asa worker. She operated a delivery by pregnant woman by blade. That is the offense. And now after getting the bail, and she died. And after getting the bail, my lord, he is not entitled for a resuming office automatically. There is some procedures where they will follow it. He has not mentioned whether she has been suspended or not. That is not mentioned in this petition. He only said that I have got bail, that I should be allowed to. That is the case.
My lord, after coming out from jail, my lord.
Show me your appointment order.
My lord, page 11, my lord.
Wait.
Type copy, page 11.
That I hereby allow Rupiah Custom so and so as per norms with effect from, what is this?
Next page, my lord, page 7.
Huh? Who does this? It is not even in a pad.
Yes, my lord.
Yours faithfully who? Who has done
It
this?
is not visible, my lord.
Huh?
It is also not visible, my lord.
Then you should have asked him. This is your appointment order.
Yes, my lord.
My goodness. Asaj are appointed in this manner, Mr. Sutia?
No, my lord, I don't understand.
Anyways, then I state that as I was in the state of Kerala for earning livelihood, so my wife went to stayed in a parental home at that on one when my wife experienced delivery, I accused being an Asha worker. Instead of taking my wife to hospital, shouting the norm after collecting medicine, the necessary medicine operated by blade, and even though there is a delivery, but the child died soon after the birth. My
My lord, the allegation is completely false, my lord, because they asked him to appear, my lord. He did not appear. That is why after the death of child.
Now what happened? You have been given under medical termination. My goodness, 302. Then you got bail.
Yes, my lord.
FL also collected the Assamese version, page 17.
Body was found incompetent. As a result, the doctor performed the could not assert in the exact cause of the
My lord, FSL report page 31, 32, my lord, nothing mentioned, my lord.
So you have got it. Now, what is your claim? That you want to resume duty?
Yes, my lord.
Why don't you ask that person concerned who allowed you to join in this manner? Do you recognize him as an ASA worker?
No, I cannot say, my lord, because the appointment letter does not say like that. Our appointment is what is this SDM to SDM. And the illegal sign is illegal at 2011-2006. By whom also that is not mentioned. Seal is not page 12. Seal is also ineligible.
My lord, one communication is there, page 23, my lord.
23.
Page 23, my lord.
Join the instant with reference to the I am directed to forward herewith a petition submitted by so and so Asa Lahorigat PSC, which is self-petitioning. Which is the communication? This one?
This one, my lord. One
So and
representation
so
was
by
filed.
no, this is by you.
No, I filed a representation, my lord, before the deputy commissioner. Deputy commissioner forwarded it to the joint director, my lord, for necessary action. No necessary action has been taken till today, my lord. And my lord, next page, I filed
Okay, Mr. Counsel, will you only issue notice, nothing more. Heard Mr. A.H.M.R. Chaudhary, the learned counsel for the petitioner. Mr.
I am put as 3 only one.
I am for 1, 2, 4, and 5, my lord.
Mr. D.P. Bora appears on behalf of the respondent number 1, 2, 4, and 5. And Mr. T.C. appears for the respondent number 3. Issue notice making it returnable on 12th of June 2023. As the respondents are duly represented, extra copies of the petition be given, be served by 2nd of May 2023. The case of the petitioner herein is that the petitioner claims to be working as an ASHA worker while discharging her duties in view of a FIR being filed, alleging FIR being filed by who is filed by one Khairul Islam. The petitioner was arrested. FIR was filed by one Khairul Islam, which was registered as Lahorighat PS case number 623/2021. The petitioner was arrested. Subsequent thereto, when were you arrested? Arrested when were you arrested? On 19/9/2021. Thereupon, the petitioner applied for bail thereupon, the petitioner was granted bail by this court in bail application number 3393/2021 by an order dated 10/12/2021. The petitioner thereafter, upon being released on bail, have been pursuing with the respondent authorities for being allowed to perform her work as an ASHA worker. However, the respondent authorities having not ventilated the grievance of the petitioner is before this court. The respondent shall apprise this court on the next date as to why the petitioners have not been allowed to rejoin her service, rejoin her services.
Well,
Yes, Mr.
Petitioner is Latmandal, my lord. He was arrested on 23/9/2022, lordship. Then he was placed under suspension by the Deputy Commissioner, Nagaon. Then, my lord, he was granted bail by this honorable court after a period of 14 days, my lord. Then, my lord, he was placed under suspension at page, my lord, 16.
Page
16, 16, lordship.
16. Deputy Commissioner?
Yes, my lord.
Which Deputy Commissioner is this?
Nagaon district.
Yes, tell me.
Yes. Then, my lord, some articles very important, passbook, etc., my lord, which were seized by this authority under ACB, my lord, is at page 17. Here, passbook and other things are there, my lord, very important. It has not yet been released. So, my only humble submission that, my lord, he has submitted one representation also. It is at page 21.
You have earlier approached this court. Why you again approaching this court?
No, this is not my case. That was another case, similarly situated person.
You want that order?
Yes, similar order.
My lord, this is a premature case. In lordship judgment, my lord judgment, Rafid Ali, 455 of 2023, my lord. Lordship may kindly have a look, Annex of 5, page 21. He has submitted the representation before the Deputy
Annex
Commissioner.
5, page 21.
My lord. He has submitted the representation written here in below, 21 to 23. Then it will be over in 21st of May, my lord, 90 days. It's a premature case, my lord, as per Rafid Ali.
They don't notice me kindly.
No.
Why notice? Premature matter.
My lord.
Still, they didn't consider, my lord. Only few days left, my lord.
Few days?
No, my lord.
Only few days.
21st of May.
If they have submitted earlier also any representation, my lord, I have no copy. But only I have received this copy. That's why I have annexed it. And his wife also submitted another. Date is not given.
When is the period going to end?
21st of May, my lord. He has submitted the representation as per the 21st of February, my lord.
I adjourn it for 4 weeks.
My lord.
In the meantime, you can take.
My
I don't need to speak anything on.
My lord. I'll get instruction, my lord.
No, don't get instruction. You do what is required.
My lord.
His only case is that you
My
know now. You have put in by filing of the petition, you have been doubly put into here. Now you know it.
My
So
lord.
you do what is required.
Lordship.
Mr. R. Goswami, the legal counsel for the petitioner, request for an accommodation in the matter. Accordingly, let the matter be listed again. A request for an accommodation for 4 weeks in the matter. Accordingly, let the matter be again listed on 26th of May 2023. Ms. M.D. Bora appears on behalf of.
2 and 3, my lord. The respondent. 2 and 3.
What is that?
Deputy Commissioner and the
Office of the Deputy Commissioner?
and the circle officer, my lord.
Office of the Deputy Commissioner, which is also the disciplinary authority. Mr. S. Dutta appears for the revenue?
Yes.
For the revenue.
I'm deeply blessed. Lordship
I
is
hope
fixed
you
on 6th
do
of May,
that.
my lord.
Huh?
6th of May.
No, I am fixed on 26th of May.
26, my lord.
26.
My lord.
In the meantime, you do whatever is
My
required.
lord. My lord. Oh, bless my lord.
13,
Yes, Mr. Gorgi.
My lord, petitioner before your lordship, my lord, was my lord granted my lord provisional pension, my lord, when he filed one writ petition, my lord. Subsequently, my lord, in this writ petition, my lord, director, my lord, submitted affidavit, my lord. Where, my lord, there was no statement regarding my lord recovery of or overstay, my lord. Therefore, my lord, on good faith, my lord, I, my lord, withdrew this earlier writ petition, my lord, with liberty to file afresh, my lord, if necessary, my lord. But now, my lord, they have stopped, my lord.
Mr. First and foremost, Mr. Borhuya,
Yes, my lord.
why do you enclose judgments of the court? Tell me in your writ petition. Why is it necessary?
No, not necessary, my lord. Just,
Then that to reported judgments.
yes, my lord.
Why you
No, it was not necessary.
I would have understood Judgments which are not reported, you are bringing it by way of filing it along with the writ petition. Why you are including Pandit Jagadishwar Prasad?
Yes, my lord.
Why you are including Manohari Das?
Yes, my lord. It was not necessary, my lord.
Then you want to make it fact.
Yes, sir.
I remember this case.
Yes, my lord.
At that point of time, they did not do that. And therefore, I gave you you withdrew it
Yes, my lord.
with liberty to take action, file if they take steps. Now they have taken steps.
No, my lord. Only, my lord, steps taken, my lord. My lord, provisional pension stopped, my lord.
What?
Yes, my lord. My lord, I have made the statement, lord, to kindly have a look. Page 10, my lord, parrot 9, my lord, I have stated, my lord.
Earlier, you were getting provisional pension.
My lord, total pension, my lord, in the meantime, my lord, provisional pension, my lord, because my lord, he is a teacher, my lord, LP school teacher, very financially very weak, my lord.
Now tell me, is it a case of wrong fixation or what?
No, my lord, overstay.
How? How did the overstay happen?
My lord, even till today, my lord, retirement notice is not given, my lord. He was
Not
verbally,
even, it is okay, but why the overstay had happened?
my lord, because, my lord, I was expecting, my lord, as usual, my lord, retirement notice could be, my lord, provided.
Understood, but was your, if I remember, on that day, Mr. B. Kaushik had produced the service book.
Yes, my lord.
Your date of birth was properly mentioned. There were two cases.
Yes, my lord.
One case that day I disposed of.
Yes, my lord. Not mentioned.
And they were not mentioned, but in this case it was mentioned.
My lord.
And you didn't have a case. Remember?
Yes, sir.
When the service book was produced by Mr. B. Kaushik.
Because one aspect, my lord, with all respect, my lord, I get to mention before your lordship. Because, my lord, even otherwise, my lord, employee, my lord, does not know the exact, my lord, formally, my lord, what is his actually date of retirement, my lord. Therefore, my lord,
Why?
Because, my
Why
lord,
is it not?
the advertisement, my lord,
Huh?
in the advertisement, in the appointment, and in the course of service, never, my lord, it was communicated that, my lord, you will be retired, my lord, at the age of 60 or 62 or 65, my lord. In the another important aspect is that, my lord, when this petitioner joined, my lord, age was, my lord, 58 years, my lord. In the year 2005, 6 like that, my lord, it was increased to, my lord,
59.
60 years, my lord.
2005 is 59.
Yes, my lord. Therefore, my lord, it is always changeable, my lord.
So, are you saying this argument you made in that earlier matter also? I have mentioned it in my but let me ask you a simple question.
Yes, my lord.
At the time of your appointment, you thought it to be 58.
58 years.
So you shouldn't you have retired early?
Yes,
or approach then look here, I have already 1850.
But I have stated, my lord, from the, my lord, normal, from the public mouth, my lord, we know, my lord, but legally, my lord.
Obviously, if your argument this point makes no sense. You should have then said that I should have retired in 58. You have got an additional 2 years bonus, and now after getting this 2 years bonus, now you want more. How much is the overstay?
My lord, almost 3 years.
What?
Almost 3 years.
63. You don't have a case. That is why I allow this. That if the petitioner, the respondents are not doing anything, why you are doing it?
My lord, they are, my lord, custodian of my service book.
So you don't know what is your date of birth.
As a teacher. But, my lord, definitely, my lord, as a teacher, metric pass, my lord, he cannot, my lord, logically deny that I don't know my date of birth, my lord. But
and then in the service book, your date of birth is recorded, and your signature is also there, if I remember correctly.
Yes, my lord.
That is why I allowed it.
My lord, in between, my lord, balance maybe lord should consider, my lord, because, my lord, they are employer, my lord, and I am employee, my lord. Always I am something expecting from them, my lord. And I am working, I am getting, my lord. So, my lord, with all respect, my lord, balance goes in favor of, my lord, petitioner, my lord. So far, I, my lord, understand, subject to your lordship's opinion. and provisional pension is not given. In any case, my lord,
You have not got your provisional also.
my lord, it was given initially, my lord, after filing this withdrawn, my lord, writ petition. But when writ petition was withdrawn, my lord, suddenly they stopped, my lord, from February 2023, my lord. I have stated, my lord, at paragraph, my lord, this fact 9, my lord.
Have you made the director of pension a party?
Party, my lord.
There is no director of pension, no, Mr. Chalo will issue notice. Or Mr. A.M. Borhuya, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the respondent number 1, 3,
5, 6, and 7, Lord.
5, 6, and 7. Mr. Mr. T.C. Suti appears on behalf of the respondent number 4. Mr. A. Solia appears on behalf of the respondent number 2 and 8. Issue notice making it returnable on, well, why do you stop the provisional pension?
Lord, that I have to stop him.
We have it on 31st of May. Issue notice making it returnable on 31st of May. This is the second round of litigation by the petitioner pursuant to the liberty so granted by this court by the order dated 22/2023 in WPC number 6403 in 2655/2022. It is the case of the petitioner that the petitioner was initially getting the provisional pension, but pursuant to the withdrawal of the said petition, the petitioner's provisional pension was stopped. It is the further case of the petitioner that till date there has been no order of any recovery issued by the respondent authority. However, till date, although the petitioner have retired as far back as in the year 2018, but till date, the petitioner have not his pension has not been finalized. The respondents in the elementary education department as well as the director of pension shall apprise this court as to why, as to what is the status of the petitioner's pension proposal and as to why the provisional pension of the petitioner have been stopped with effect from
February 2023.
February 2023.
Item 14 for admission.
Yes.
This is regarding non-payment of salaries from the date of appointment till the date of retirement.
No salary from the date of appointment to date of retirement. You were appointed as a teacher?
Teacher, yeah.
And government submits that he has filed an affidavit?
Lordship, you have filed affidavit in terms of your Lordship's order.
What is it?
To being on record, Lordship may kindly take up the
affidavit. Additional affidavit also we have filed reply.
Petitioner is illegal.
You have filed an additional affidavit on
Lordship.
23.
Lordship.
What is the stand?
Lordship, the petitioner has not
Whether he has been considered in the incident has been filed pursuant to the passed by this court so as to bring on record the stand by the department why the petitioner has not been considered for accommodation as a teacher tutor with prospective effect pursuant to the. In order to explain the stand of the answer, the officer would like to give a brief background of the constitution of screening by the government legal. In terms of the
Yes, sir.
Yes.
Lordship, if your lordship comes to page 12 of my petition, your lordship, there is regular selection process, and the sub-divisional selection board selected me for appointment, your lordship. Pursuant to that, I was appointed, and thereafter the government also directed the district elementary education officer to release my salary, your lordship. To release my salaries after my appointment, the government directed the district elementary education officer to release my salaries. But the DEO wrote a letter to Treasury to release my salary, but the name of my school was wrongly adduced, your lordship. Therefore, that was not released. And thereafter, your lordship, there was a rectification done, and the corrected name of my school was furnished to the Treasury officer. Even after that, my salaries were not released, your lordship. And I retired from service in 2021, your lordship.
এখানে affidavit যে file করেছে, he has a copy of it.
Yes.
Kindly give a photocopy of that affidavit
Yes.
here. Na? I should keep it here because this is what it
Required. In
is.
some
It is
other
required
cases
because
also.
so many cases are
Yes.
there. Means
Yes.
how the tutor thing came.
Lot.
Moreover, your lordship, I was never ever informed that my service appointment was illegal, your lordship. In view of the fact that there was a selection process, a regular selection process selected by the sub-divisional selection board, and I was appointed. From the date of my appointment till the date of my retirement, I was never informed that my appointment was illegal, your lordship. And I have rendered 22 years of service, uninterrupted service, your lordship.
But you have not received a salary since from your date of appointment.
From 1999 to 2021.
Then you don't even have that particular degree also. That particular qualification of having a
I was
training.
never directed to get the B.Ed degree, your lordship. I was never directed.
No, you went and submitted for verification.
Yes.
And in the
There after no
verification, it was found out that you came within the ambit of this 8,400.
There was no communication after that. Only I was asked to
No.
furnish my.
But Mr. Counsel, this verification which is being done is a fact-finding inquiry.
Yes, lordship.
How can this court look into it? Tell me, unless you show perversity to
What happened is, your lordship, I was called by the DEO, and my joining letter.
In fact, your name was
Yes,
not
sorry.
there. Your name was not there in Porpeta. It was your name was not there in Baksa, but it was found in Porpeta.
Originally, I was appointed in Bogota, your lordship. That is why.
But it was found that you have not received a single penny, neither you have the training, and as such, they did not regularize you. And why? I don't understand why you have been working for such a long period, 21 and plus 1, 22 years, without a salary.
There was an expectation that I will be paid, your lordship.
Is there any legitimate expectation that the government one fine day would pay you the salary?
My legitimate expectation emerges from the appointment letter, your lordship.
Now, their records, they have given on affidavit that you see, you don't come, your salary, your appointment was not recommended at that point of time. But you were continuing with the job.
But that was not intimated to me, your lordship. I was never intimated. And I was never asked to discontinue my services, your lordship. And I was.
If your appointment was not regular or illegal or irregular, they may not do so.
That was also not informed, your lordship. That
Were you appointed again the sanction post?
There was an advertisement, and I personed to the.
Where is the advertisement?
That
Where
was
is
in
the advertisement?
1999, your lordship.
Then?
That was in 1999. And I rendered my services for 22 years, your lordship.
Understood, but why were you working? That is the problem.
If my appointment was illegal, Your Lordship, the government should have.
So you had a legitimate, expectation.
That emerges from the appointment letter, Your Lordship.
That appointment letter does not inspire the confidence.
When the government
Every day, Mr. Sharma, every day I get I keep on looking into these are type of appointment letters, which are all these are excess teachers and all these things people out there. These appointment letters which you are referring to is most of the appointment letters are on excess teacher cases.
The petitioner here is the
This is not against the year.
But how would one know, Your Lordship?
You have been appointed, just for example, I'm just giving you an example. This is done under what provision? This appointment letter which was issued under what provision? 1974 Act and the 77 rules. If you see, in none of the cases at that point of time, the persons were initially appointed on a stipend. And thereupon, pursuant to the training which was done under Section 4 or Rule 4 of the Elementary Education Service and Conduct Rules, 1981, they were being given that. But why on the first day you have been given a regular scale of pay? Can a regular scale of pay be given in this manner? And on the basis of this particular document, do you have a claim only? That is the biggest problem I see. And you have not got a single salary. You must have to be appointed against a post. All these applications, all stipendary teachers, if you see, they are appointed against a particular post. That have not been done.
Compassionate appointment, Your Lordship.
Huh?
Compassionate appointment, Your Lordship.
Your case is a compassionate appointment. Where?
The list itself says, Your Lordship.
It is not so. It's a selected candidate by the subdivision and selection board. This subdivision and selection board which you are referring to is in terms with 3.6 or 3.4 of the elementary education rules, as it was prevalent prior to 2005.
Lordship, it's not compassionate.
No, it can't be compassionate. This is the selection, how it is done. But I don't understand how could you have been given not against the vacant post, one. It is always, all appointments have been made against the vacant post, or the post has been mentioned. And further to that, it has also been mentioned, here it is mentioned, you see, by Sri Matyar Rahman, assistant teacher transferred. Now, can against a transferred vacancy, there be a particular thing?
Lordship, if
Not
Your Lordship
possible.
comes to page 17, Your Lordship.
Can there be a vacancy created on the basis of a transfer proposal?
If Your Lordship comes to page 17, this is a list of teachers appointed against date, retirement, vacancy. So there are vacancies, Your Lordship, at page 17. And my name features at page 18, serial number 54, Your Lordship.
This was done in 2000.
Yes, Your Lordship.
Where is the forwarding with reference to
2003,
the
Your
letter?
Lordship.
With reference to the letters of the, I am directed to you to release the payment of salary or as per the list. This is being given by the Secretary to the Government of Assam Education Department to the so and so. And your name was there
Lordship.
in Adarsha Vidyapit. Now here your appointed was to Korapara
Yes,
HS
Your
school.
Lordship.
Then
That name was.
it does not inspire. I'm coming to dismiss your petition in 5 minutes. Yes.
In a similarly situated case, Your Lordship, by the same select list, another person, Manav Nath, was selected. His name features at serial number 45, page 18, Your Lordship.
Yes, I've seen it.
In that case also, the appointment letter is similar, Your Lordship. I have the copy of the appointment letter in respect of that case also. And in that case, Your Lordship, the Honorable Court was pleased to release the salaries to the authorities to release the salaries to the petitioner, Your Lordship. That is WPC number 3912 of 2014. Your Lordship.
Where is it?
By an order that uh, '28 1 2016. This is the order, Your Lordship. This is the order passed in that case, Your Lordship. 3912 of 2014. His name features at page at serial number 45 in the select list. Your Lordship. I've rendered the services for 22 years, Your Lordship, and without any salary. At least my salaries may be paid, Your Lordship, because the state authorities will utilize my services without paying anything. That doesn't conform to the idea of welfare state, Your Lordship. And moreover, Your Lordship is aware that judgment of 2016, Your Lordship, 2016 1 SCC. I was never communicated that my services should have been terminated if that was illegal, Your Lordship. If the appointment was illegal, I should have been terminated, and I must have been intimated that my services are terminated. That was not done, Your Lordship. Even after my retirement, the DEO called me to his office and asked for some letters, Your Lordship, documents. And
Mr. Counsel, you are referring to a particular order by which, kindly see that order at paragraph number 8. It records a report submitted by the Director of Elementary Education, wherein it says that the person concerned was duly selected pursuant to a selection proceedings, and his appointment was not made during the ban period. Further, it has been mentioned that the pair was initially posted by the district elementary, again transferred against the vacancy of so-and-so Hindi teacher at so-and-so. And even though the petitioner was selected as serial number 22 of the select list as a general assistant teacher, these are the facts in respect to that case. How do you apply the same facts here?
the select list is the same, Your Lordship. Page 17, that is the select list, Your Lordship. List of teachers appointed against dates.
Where is the select
determined
list?
vacancy from select list, Your Lordship.
Where is the select list?
That is at page 17, Your Lordship.
Page 17 is not the select list. Page 17 is a direction for making payment of the salaries. That's not a select list.
That refers to the select list, Your Lordship.
No, this can't be a select list. You see what is there at page 17. Page 17 is preceded by page 15. This is the enclosure. How are you saying this to be select
They were
list?
selected, Your Lordship. That is why this is the.
No, there's no select list business out there. Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the
1, 2, and 3, Lord.
respondent numbers 1, 2, and 3, and 5. Mr. Arbo Puzari appears on the. Oh, you are appearing for 5. 1, 2, and 3. Mrs. R.B. Bora appears on behalf of the respondent number 5. Mr. Arbo Puzari appears for the respondent number 4. The issue involved in the instant writ petition is relating to the payment of the salary to the petitioner, which admittedly the petitioner have not received since the date of his appointment. It appears from a perusal of the writ petition that the petitioner claims to have appeared in a selection process pursuant to an advertisement and the petitioner was appointed by the district elementary education officer as assistant teacher in the scale of pay of rupees 3,130 to rupees 6,600 per month, plus other allowances as admissible under the rules, and was posted at Horapara HS School by one Matiar Rahman, assistant teacher, transferred. It further reveals that the undersecretary, the secretary to the government of Assam, Education Department, had directed the district elementary education officer, Borpeta, with a request to release the payment of salaries of 58 number of teachers in ME schools as per the list enclosed. The petitioner's name in the said list appears at serial number 54. However, the petitioner did not receive the salary and continued to render her services It further appears from the records of the writ petition that some verification proceedings were initiated by the state government, and the petitioner was issued a notice on 1/11/2014 in connection with irregular illegal appointments from 1991 to 2001. It is the case of the petitioner that as the petitioner had rendered service from 1999 till 2021, the petitioner is entitled to the salary for this period. And being aggrieved by the inaction on the part of the respondent authorities in not making payment of the salary, the petitioner has approached this court by filing the instant writ petition. In the year 2017, yeah, I got it. 2000. It is the case of the year 2021. 2017. It appears from the record that this court, by an order dated 30/10/2017, issued notice. The record further reveals that the Director of Elementary Education had filed an affidavit in opposition on 6th of April 2022. In paragraph 7 of the said affidavit, it has been mentioned that the school in question falls within the jurisdiction of the Boroland, the school wherein the petitioner was appointed. On 6/12/2019 falls within the jurisdiction of Boroland Territorial Area District. It was mentioned that the petitioner's appointment as assistant teacher at Khorapara ME School, KUR, Khorapara ME School, was an illegal appointment for which the petitioner did not receive the salary. It has been mentioned that although in the government's order dated 21/12/2000, there was a direction for payment of salary to 58 numbers of ME school teachers, wherein the petitioner's name was included at serial number 54. But the school in respect to which the petitioner name was shown, against which the petitioner's name was shown, was one Adarsh Vidyapit ME School, which was not in terms with the appointment letter of the petitioner. It has been further mentioned that the district elementary education officer wrote a letter to the treasury officer. Mr. Sharma, I have heard you. I'm passing the order. Anything you want to say? There's a division bench. Sit down. It has been further mentioned in the said affidavit that the district elementary education officer, Borpeta, wrote a letter to the treasury officer, Borpeta, dated 9/4/2001 to release the salary of the petitioner. In paragraph number 10 of the said affidavit, it has been further mentioned that the then district elementary officer, Borpeta, wrote a letter to the treasury officer, Borpeta, dated 13/6/2001, correcting the name of the school, which was earlier issued by letter dated 9/4/2001. It was further mentioned that as per the WT message dated 30/12/2014 of the Commissioner Lower Assam Division, Guwahati, conveyed by the Deputy Commissioner Borpeta, dated 31/10/2014, the then DEO Borpeta issued a letter dated 1 11/2014 to the petitioner for verification of the records in connection with irregular or the illegal appointment from 1991 to 2001. It was mentioned that the government in the elementary education department constituted a screening committees for the purpose of screening the illegal or the irregular appointed teachers working in the lower primary and upper primary schools of Assam. Via an office order dated 15/11/2011. Accordingly, advertisement dated 1/2/2012 and 4/2/2012 were issued. It is in pursuance to that, the letter dated 1/11/2014 was issued to the petitioner to appear before the screening committee for verification of the records. It was further mentioned that a list of teachers, tutors, for accommodation of illegal or irregular tutor was issued by the Elementary Education Department, Assam, to the Director of Elementary Education on 21/1/2021. However, in the said list, the petitioner's name did not appear. It was further mentioned that the entire matter of illegal or irregular teacher or tutor have been centrally dealt by the government in the Elementary Education Department. It was also mentioned that as per the report of the DEO, Corpeta, the original joining letter of the petitioner have been seized by the Chief Minister's Vigilance Cell on 6/7/2012. To the said affidavit in opposition filed by the Director of Elementary Education, an affidavit in reply was filed by the petitioner on 8/6/2022. In the said affidavit in reply, it was reiterated that the petitioner was regularly appointed by the authorities under the government of Assam, but she was not paid her salary for no fault of hers. It was mentioned that it is incumbent upon the respondents to release the salaries of the petitioner to relieve her from the woes suffered by her for such a long period of time since 1999. It was further mentioned that the appointment letter dated 6/4/1999 amply testifies that the petitioner was regularly appointed teacher after a proper selection process. And the annexure B, C, and D to the writ petition clearly goes to show that the petitioner was entitled to the salary. It was further mentioned that the non-inclusion of the name of the petitioner in the list mentioned at paragraph number 11 of the affidavit in opposition filed by the Director of Elementary Education is also an ample testimony that the petitioner was not an illegal teacher, which is strongly supported by Annexure B, bracket, appointment letter dated 6/12/1999 of the writ petition 6427/2017. And therefore, it is extremely misleading to say that the petitioner was an illegal teacher. This court further finds it relevant to take note of that on 23/1/2023, when the matter was listed before this court, this court inquired with the learned counsel, standing counsel for the Elementary Education Department as to why the petitioner has been considered as an illegal teacher by the District Elementary Education Officer, Borpeta, as reflected in Annexure 2 of the affidavit filed by the Director of Elementary Education. The standing counsel appearing on behalf of the Elementary Education Department had produced an instruction dated 21/2023 issued by the Director of Elementary Education. However, the said instruction was completely vague in respect to the query so made. On the very date, the learned counsel for the petitioner had also apprised this court that the petitioner retired from service in the year 2021. And all along, the petitioner served as the assistant teacher in the school in question. This court further directed the Elementary Education Department to obtain instruction as to what had happened pursuant to the verification of the records of the petitioner and whether the petitioner was duly intimated about her termination from her service, in as much as a termination order kept in the file cannot be said to be a termination in accordance with law. When the instant writ petition was again listed on 15/2/2023, the standing counsel for the Elementary Education Department placed on record another instruction dated 9/2/2023, along with a communication issued by the Deputy Secretary to the Government of Assam, Department of School Education, to which there is a list of illegal teachers to be filled up in the district personnel as well as the cabinet memorandum. The petitioner's name appeared in the said list. It was also submitted during the course of the hearing that as the petitioner did not receive a single penny since her date of her appointment, the question of creating a supernumerary post for the purpose of payment of the petitioner's salary did not arise. This court, taking into account the specific stand of the Elementary Education Department, directed the Elementary Education Department to file an affidavit so that the petitioner could rebut to the same. Accordingly, on 23/2023, an additional affidavit was filed by the Secretary to the Government of Assam, Department of School Education. It has been mentioned that in terms with the order dated 2/3/2010, passed by this court in WPC number 1048/2004, the Education Department placed the matter of regularization of the irregular teachers before the Cabinet in its meeting dated 26/2/2011. The Education Department proposed to constitute a screening committee to examine the validity of the appointment of the teachers who are claiming regularization and salary. Accordingly, an office memorandum dated 15/11/2011 was issued whereby a screening committee was constituted to examine the cases of illegal appointed teachers so as to take a decision for their regularization and entitlement of salary or otherwise. In order to examine the selection procedure, it was thought, it was the committee decided to examine the nature of appointment, status of the posts, working status, status of salaries, academic qualifications, etc. The Director of Elementary Education thereupon invited applications from their illegally appointed teachers during the year 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in local newspapers. Pursuant to the said advertisement. Next. Various applications were received from illegally appointed teachers throughout the state who were appointed during the year 1989 and 1991 to 2001. After carrying out a preliminary examination at the directorate level, a total of 12,085 numbers of applications were found in order, and the same were submitted to the government for final verification. Thereupon, the Elementary Education Department, by notification dated 4/6/2014, constituted 5 screening committees headed by the divisional commissioners concerned and the principal secretaries of the 6 scheduled areas and BTC to examine these applications and the report of the preliminary committee. The said 5 screening committees were as under: number 1, Roman 1, Upper Assam Division, Roman 2, Lower Assam Division. Number 3, North Assam Division. Number 4, Hills and Barak Valley Division. And number 5, BTC area. It was mentioned that the petitioner had also participated in the said screening process pursuant to the receipt of the notice dated 1/11/2014. Next. Thereupon, the divisional screening committees, so constituted, verified all the applications and submitted their reports with recommendations, views to the government for further action. It was also mentioned that due to certain complaints from various corners, the government directed for re-verification in respect of some of the districts. The respective screening committees, after causing re-verification, submitted their reports to the government. After verification of the reports of the divisional screening committees, the following categories of teachers were identified. Number 1, category 1, that's recommended and working till date. That's 136. Category 2, that's recommended but discontinued jobs. That's 250. Category 3, that's not recommended but working till date. That's 8470. Category 4, that's not recommended and discontinued jobs. That's 2,900. Next. Pursuant to the reports submitted by the screening committee, a decision was taken to regularize the services of the teachers who fell in category 1. And subsequently, their services were regularized. As regards those in the category number 2, the question of regularization of their services did not arise, taking into account that they did not continue in the jobs. As regards the category number 4, also, the question of regularization and payment of the salary did not arise, as they were neither recommended nor continued in the jobs. However, the issue pertaining to the category number 3, remained to be decided as to what action, what steps is required to be taken, taking into account that they were not recommended but were working. Under such circumstances, a decision was taken by the state government to issue individual show cause notices to all the 8470 candidates and 766, including 752 terminated teachers of Dhemaji and Lakhimpur district, indicating therein to show the reason as to why their appointments are not deemed to be illegal or irregular, and as to why they should not be removed from service for being appointed in violation of the existing rules. Next, although the government took the decision to issue show cause notices, but in the meantime, a discussion was held between the Minister of Education and the Teachers Association, or irregular or illegal teachers. As per the decision in the meeting, and as per the suggestion of the Minister of Education, the department proposed to take a decision to solve the problems of these irregularly or illegal appointed teachers subject to the approval of the cabinet. Accordingly, a departmental committee was formed by the government to verify the salary status and qualifications of those category 3 illegal or irregular appointees. The said category, the teachers in the category 3 were further bifurcated into 3 lists. First, list 1, that is the teachers who had received salary at some point of time and having JBT / D.el.ed. This is, what is this? DELED?
Diploma in Elementary Education.
Elementary education.
JBT is Junior Basic Training.
The total number of such teachers found in the list 1 was 1574. I told you. List 2 were those teachers who had received salaries at some point of time, but not having JBT / D.el.ed. In the said list, the number of teachers included was 2960. The list number 3, list 3 are those teachers who neither received salaries nor qualified the training, that is JBT / D.el.ed. In the same categories, there were 7250 teachers. In order to resolve the said issue, the department decided to prepare a cabinet memorandum for placing it before the cabinet. The proposals were submitted by the Education Department were, number 1, approval sought for approval was sought for accommodating those teachers who had received salary up to 2007 and have successfully completed the junior basic training /D.EL.ED course by certain personnel supernumerary posts with prospective effect from the date of approval of the cabinet. Those supernumerary posts would cease to exist as and when the incumbent retires from service. That is, list 1 as teachers. That is list 1 as teachers. That is opera agopa bracket open kori. That is or agot open kori teacher episode close kori. B, approval was sought for those who received up to 2007 but have not acquired the professional qualification before 2011. Their job can only be accommodated as a tutor with prospective effect from the date of approval of the cabinet. Prospective effect from the date of approval of the cabinet bracket, that is list 2 as tutor. It was further mentioned that the fixed salary for the tutor is as per the Assam Education bracket provincialization of services of teachers and reorganization of education and institution bracket close Act 2017. As regards the third category, and next, it is relevant to take note of that there was no proposal so submitted to the cabinet in respect to those teachers coming within list 3, that is, who neither received any salary nor qualified the training, that is JBT/D.EL.ED. In respect to the petitioner, it was further mentioned at paragraph number 10 of the additional affidavit that the name of the petitioner was found in the screening committee report under Borpeta district and not Baksa district. And as per the screening committee's list, under Borpeta district, the petitioner had neither received any salary nor has completed the junior basic training, and therefore she does not fulfill the criteria laid down in the cabinet memorandum, for which the petitioner's case could not be considered for accommodation as teacher/tutor with prospective effect pursuant to the cabinet approval dated 7/10/2020 on the basis of the report of the screening committee. The screening committee's report, insofar as the petitioner was concerned, was enclosed as Annexure A to the additional affidavit. Next. The petitioner, upon receipt of the said affidavit in opposition, additional affidavit, filed an affidavit in reply on 28/3/2023. In the said affidavit in reply, it was mentioned that it is on record that the petitioner was appointed through a regular selection process conducted by the respondents, and the petitioner had rendered service sincerely and diligently from the date of the appointment till the date of superannuation without having been paid her salary, in spite of there being communications among the respondents for release of her salary, which was never released. It was mentioned that the petitioner had also participated in the verification process, as was called by the respondents. And the petitioner was never informed anything about her appointment being illegal during the whole span of her career, from the date of appointment till the date of superannuation. It was further mentioned that there was no justifiable and tenable reason for declaring the petitioner as illegal. And this very aspect was never intimated to the petitioner during the whole span of her career, which the petitioner for the first time came to learn on the basis of the additional affidavit. It was further mentioned that obtaining a B.Ed degree is not possible without the respondent authorities issuing direction or instruction for the same and providing facilities for pursuing the same. And it is a case of total perversity that the petitioner's appointment have been categorized as illegal. On the aspect that the petitioner's case, petitioner's name was found in the Borpeta district and not in Buxa district. It was mentioned that in the year 1999, when the petitioner was appointed, the school was within the limits of Borpeta district. And subsequently, with the formation of the Buxa district, it came to be in Buxa district. It was further mentioned that finding the petitioner's name in Buxa or Borpeta district cannot render the appointment of the petitioner illegal. Yes, Mr. Sharma, what did you want to say? Now tell me.
That has been taken care of by your lordship.
What?
That the rectification of the name of the school.
Huh?
Rectification of the name of the school, your lordship.
Okay. Now, Mr. Sharma, tell me the other Sharma. Why have you categorized the petitioner as illegal? Because he has not received salary.
Lordship, the list is there.
Huh?
The list of illegal teachers of Lordship may find in page number 37 of my affidavit.
Which affidavit?
The additional affidavit, Lordship.
Page 37, yes.
Lordship. List of illegal teachers to be filled up by the district person.
Now, how did you find out that it is illegal?
Serial number 1.
Now, understood. Because if you see your affidavit,
Lordship.
When all these things were taken note of,
Lordship.
There was a categorization made.
Lordship.
That these are persons who are there, recommended and working till date.
Lordship.
Recommended but discontinued jobs.
Lordship. There are two categories. For
not recommended but working till date 8470.
Lordship.
And not recommended and discontinued jobs 2900.
Lordship.
Okay. Now you have categorized the petitioner within the ambit of category 3. That it comes within the ambit of 8470.
Lordship.
Why it is not recommended, we don't know. But anyways, you have put it.
Lordship.
Now, thereupon, it seems that you have made this category, bifurcated the category 3 into another 3 lists. One is a person who have been
receiving salary
till 2007 and has the education. They are brought within the ambit of teachers.
Teacher, list 1.
The second is those who have not received, who have received salary, but have not, but doesn't have the education. And the third is both.
Both. Neither salary nor.
So in all, it is because of the non-receipt of the salary.
As well as not having the.
No. If he had, the question would have been different. There is no problem. If he had the educational qualification or no education. If he had the educational qualification, he becomes a teacher. If he does not, he becomes a tutor. So the only reason is because of non-receipt of salary. Now, what do you say about that document, which was issued, that putting her at page 54, serial number 54, against a different school, but this was subsequently corrected as stated by you in your own affidavit.
But that was by the district elementary education office.
Understood. But whoever may be, they have done it.
That was with the district elementary.
That was corrected. And this is put, no, this is put by way of you in your affidavit. You have not denied. Yes, initially, when you say that this is an affidavit which you have filed it, and in the affidavit you say that the petitioner's name appeared at serial number 54. And when it was appeared at serial number 54, it was against some other school.
Some other school. The name of the
but
school.
That was subsequently corrected. So the right of entitlement of the salary
But lordship, the very appointment letter itself is illegal.
Where is it mentioned? Where have you mentioned? Show me one document you say that you have mentioned that it is illegal, except on the basis of salary you have not put it. Why have you not recommended? Why did you put the petitioner in category 3?
Because he didn't receive salary from day one. And
No, not on list 1. Category 3, why have you put the petitioner in category 3? There are 3 categories, na? 4 categories. One was not recommended, they were regularized. One recommended but discontinued, nothing. Number 1 is not recommended, discontinued, no problem. The problem was with 8470. Why have you put the petitioner in not recommended? Why?
Because of
that is not there. There is no answer there.
lordship.
Now, Mr. Barbudari, don't you think that this appointment is a case of a regularization which is being done? There are 2 aspects of the matter. One is the question is, even those 8470 people, they had foregone all their past dues. If you see that, that is in fact, they should have mentioned in the additional affidavit, that was the catch. They have, if you see all the appointment orders of 31/2021, isn't it? All appointment orders are 31/2021. It is not here. All appointment orders pursuant to this decision is 31/2021. Everywhere at clause number 4, it has been mentioned that these appointments are given, you have to forego all your claims.
There is a condition.
So if you bring anybody in category 3 also, none of the persons would be entitled to any salary prior date.
Perhaps, my lord, in category 3, my lord, since receipt or non-receipt of salary, that has been made a condition precedent. But it may quite so happen, my lord, because salary is the immediate condition of service, my lord, on being appointed regularly, my lord, to a post. He is entitled, my lord. It is a natural consequence, my lord. So maybe, my lord, the department had viewed the matter in that angle. Because non-receipt of salary means would necessarily mean and include, my lord, that appointment is not in accordance with law. But I cannot comment on it because I do not.
There are many people who have received, so the salary was the main aspect.
It appears so from the
So
category.
if you have paid the salary, you are going to regularize.
Yeah. Now, salary is again, my lord, a natural consequence. It is a natural corollary of a person being appointed by following due process of law. Perhaps, my lord, this is what I understand.
Hello, I'll pass the remaining part
My lord.
to, let me think about it. But don't you think, if you see that state of JNK where Justice Chandrasood was exploring on what are the things what can be done, a regularization, which is as regards a regularization. This is in fact a regularization.
Yes.
By allowing them that all other past dues, you forget about it, but we are regularizing and bringing you within the ambit of the government. It's a policy decision of the government. This is a cabinet memorandum, is a policy decision of the government.
Inducting in a cadre or they are outside the cadre. This is the best.
So you were there, you have been given salary, but whatever may be, but you had some degree, and as such, we are bringing you. If you have the educational qualification, you are made teacher. If you don't have this, but the basic reason why we have done is taking into account the salary.
Correct. Because salary will be the immediate next.
Now, those people who have not received the salary,
Yes.
there we are not going to give anything. We are not bringing them within it.
Perhaps, my lord, that is the reason.
That is the reason.
Because that will
Because
again, my
out
lord,
of-
give rise to one another aspect of the matter. I am a person, I am appointed. I am not receiving salary for years altogether.
Out of this 8470 lordship,
So I am having my right.
1574 they received salary as well as they had a basic training.
That I know. Now you have brought her, brought the petitioner within the ambit of this number 3,
8470.
7250. You have brought her, the petitioner within 7250. 7250 there is no proposal, there is no decision. It seems that although they were not recommended, but the government took a decision.
Yes.
Then why not the show cause notice is issued? You see, if you see the list, how it has been mentioned out here, why is it relevant? I am saying it is. Of this 8470, government initially took a decision that will issue show cause notice. Once that decision was taken, then the minister came in. Look here, that these people we are going to accommodate them, and as such we are giving a permit. But what happened to the other? Are they not entitled to a show cause?
My lord, again, my lord,
Isn't
one
that the
aspect-
decision?
No, this is correct.
No, you have taken one. You see, in paragraph number 7, paragraph number 6, 7.
7.
There was a specific thing that we are going to issue show cause as regards this 847.
Yes.
And if this 8470, these people are show cause, then the minister comes in and says that, look, we are do something. And then you form another 3 lists, of which there are 2 lists you are giving them tutor or whatever mean.
Pursuant to the meeting of the
Yes, whatever
education
mean.
minister as well as
Yeah. But as regards the 3rd category, question of show cause, nothing is there. Did they waive their right? Can a show cause which they have or they entitled to?
So otherwise also, my lord, the person aggrieved ought to have challenged that decision of the government at that point of time. Because this petition has came to be filed, my lord.
This was filed in 2017.
2017, it was prior. This
Understood, but
petition
should
was
this court again relegate the petitioner back there again, then say to that effect?
prior. So otherwise also, affidavit pleadings are there on record. So people kindly
Everything
must-
is there.
Yes,
Now
but-
this development has happened because it was during the course. He had only asked in 2017. Then it was during the course when the Standing Council of the Elementary Education Department came up before this court and said, look here, we have taken a decision of this in 2021 and the petitioner has been terminated as an illegal teacher. He is illegal, it's well and good, but isn't it necessary that you should have mentioned in those affidavit that he was found to be illegal? There's not a single mention to the effect.
Maybe, my lord,
You have brought him within the ambit of not
it is
recommended.
not happily worded.
No, it has been brought that it is not recommended. But those not recommended also you have given because they have received salary. Now the petitioner's entitlement to the salary has not been denied to that effect that it has been given by the district elementary education in here. Then why the petitioner should not be brought out here from 2021? When did you retire, Mr.?
April 2021.
Huh?
April 2021.
When did you retire?
April 2021. April 2021.
April 2021.
Well, one another question, my lord, while my lord was dictating the order, I was, my lord, discussing with my learned colleague, my lord. If the appointment is illegal, how come there can be a case of retirement, my lord? How can a person be made to retire? If his
No, these schools, they do many things. Did you get a superannuation notice?
That I am not aware of.
Then
No.
how can that statement come before this court that I have superannuated, I have retired? Because retirement is a consequence, man.
Hello, let me think about what to do.
And consequence.
Huh?
I was verbally informed by the DEO that I retired from service.
Verbally.
And the written documents are not given because I have instituted this case. Because of this filing of this case, I was not given that in writing. That's it.
By
the DEO.
very difficult, Mr. Sharma.
That is how I'm in.
Yeah, on elementary education. I've heard the learned counsels for the petition, for the parties. The question which arises for consideration on the basis of the materials on record and the relief sought for in the writ petition is as to whether the petitioner is entitled to the salary for the period from her date of her appointment till her alleged date of retirement in the year 2021. It may not be out of place to take note of that the petitioner have not been issued any superannuation notice, but as submitted by Mr. R. Sharma, the learned counsel for the petitioner, that the petitioner was verbally informed that she would retire in the year 2021. And it is on account of the pendency of the writ petition. No superannuation notice have been issued. Be that as it may, this court finds it relevant to take note of that the right to receive salary from the state authorities would depend upon an appointment to be made in accordance with law. Be that as it may, it is relevant to take note of that this court, in exercise of the powers under Article 2 to 6 of the Constitution, would be in a position to issue a writ in the nature of mandamus for the purpose of releasing the salary of the petitioner, provided it is found that the petitioner was duly appointed in accordance with law. From a perusal of Annexure A which is the only document placed on record. To show that the petitioner was appointed as an assistant teacher by the then District Elementary Education Officer on 6/12/1999. Oh. The Assam Elementary Education bracket provincialization bracket close Act 1974, hereinafter for short referred to as the Act of 1974, was an act enacted to provincialize the services of the teachers of elementary school, including pre-primary school and the employees of the respective boards. In terms with Section 27 of the Act of 1974, the state government have been empowered to make rules for carrying out the purpose of the said Act of 1974. In exercise of the said power, the Assam Elementary Education bracket Provincialization Rules 1977, hereinafter for short referred to as the Rules of 1977, was made as the appointment so claimed by the petitioner is for in the year 1999. It would be relevant to take note of the rules as it stood prior to 2005. In as much as with effect from 11 to 2005, no, 11, 8, education manual. In as much as after 10/11/2005, there has been major changes brought to the said rules of 1977 by amendment. Rule 3, as it stood at the time of appointment of the petitioner, Rule 3 of the 1977 rules of 1977, as it stood at the time of the appointment of the petitioner, stipulated the method of recruitment in terms of Rule 3.6, Roman 6. It has been mandated that on receipt of the applications, the selection committee shall scrutinize the mark sheets and other necessary testimonials of the candidates and prepare a list of candidates for interview by the selection committee. Thereupon, the selection committee shall finalize the list of successful candidates in order of merit after interview and shall put up the list before the board for approval. While approving the list, the board shall be guided by the declared policies of the government and the instructions issued by the government from time to time. After the approval of the list by the board, the same shall be sent to the Director of Elementary Education for his final approval. It has been further mentioned that the Deputy Inspector of Schools would appoint the selected candidates in order of merit from the list approved by the Director of Elementary Education, as and when required as per the government rules and government instructions for the time being in force. When was the district elementary education officer empowered? Because at that point of time, it was not there. Because all the stipendary teachers, if you see, these are all appointed by the Deputy Inspector of Schools. If you remember those matter as I was taking up, the stipendary teachers, all these teachers are appointed at that point of time by the Deputy Inspector of Schools. It was never the district. It must have come later on, after the 2005, I suppose. It is further relevant to take note of the provisions of, take note of that, take note of the Assam Elementary. At this stage, further, this court finds it relevant to take note of another rule, another set of rules known as the Assam Elementary Education (provincialization) Service and Conduct Rules 1981. In terms of rule, herein called the rules of 19, referred to as the rules of 1981. In terms of rule 3, Roman 6, it has been mandated that the recruitment to the post of the teachers in elementary schools shall be made under the provisions of Part 1 of Rule 3 of the Rules of 1977. It is also relevant to take note of Rule 3, Roman 5 of the Rules of 1981, which mandate that the teachers on appointment should be required to undergo junior, basic, or normal teachers training course or any other training recognized by the government. Rule 4 of the Rules of 1981 relates to confirmation. In terms of the said rule, which mandates that subject to availability of a permanent vacancy, every member of the service shall be confirmed in the cadre / class / grade to which he/she is appointed substantively if he/she has completed at least 3 years continuous service after provincialization, or he/she has successfully undergone necessary training as may be prescribed by the department and facilities for which have been offered to him/her by the department during the period of 3 years. The proviso to Rule 4B further stipulates that those teachers who have completed 45 years of age or have completed 3 years of continuous service after provincialization, but no facilities have been provided to him/her for the prescribed training, will be confirmed provided there is nothing adverse against him/her. Further to that, the second proviso to Rule 4B stipulates that all teachers whose services have been confirmed and approved by the State Board of the Regional Board prior to 5/9/1975 shall be deemed to have been confirmed duly with effect from the date of such confirmation. What is the rule for pay? What is the rule for pay? How do they get the salary?
I have to ask if he will be in a position.
How do a person gets a salary? What is the rule for that? ROP.
Otherwise, ROP.
In terms of Rule 5B, it has been mandated that all matters relating to pay, allowances, leave, pension, discipline, and other conditions of service shall be regulated by the general rules framed by the government from time to time.
Because, my lord, the ROP rules categorize the various posts, my lord, against which, my lord, the salaries are earmarked.
DEE means Director of Elementary Education, District Elementary Education.
DEO is district elementary.
No. I am saying is, you see, Director of Elementary Education.
He is delegate.
Because in 2055, the amendment gives the power to the Director of Elementary Education. Where does the District Elementary Education come in?
No, Lord. The appointing authority is the director.
Earlier, it was the Deputy Inspector.
DIF school, Lordship.
So he was never.
DEO was never appointing authority.
DEO was never an appointing authority.
No, never.
This court further finds it relevant to take note of. That in the year 2000, that the rules of 1977, upon being amended by notification dated 10/11/2005 with effect from 10/11/2005, and more particularly clause 6 B, small b, C, capital C, only empowers the DEE to issue the appointment letters to the candidates from the select list of the DLC in a salary provided by the government from time to time till the successful completion of the prescribed training. It is also relevant to take note of that the term DEE have been defined in Rule 2, Roman 4 to mean the Director of Elementary Education. Therefore, from a perusal of the rules of 1977, as it stood prior to the amendment of 2005, the appointing authority was the Deputy Inspector of Schools, and pursuant thereto, after 2005, after 10/11/2005, is the Director of Elementary Education. However, if this court peruses Annexure A to the writ petition, which is the only document shown as regards the appointment of the petitioner, is a document issued by the District Elementary Education Officer, Borpeta, who was not the appointing authority. Under such circumstances, the appointment letters so issued by an authority who was not empowered would not give any credence to the legality of the appointment of the petitioner. Full It would also be seen that there is no materials brought on record that pursuant to the appointment of the petitioner was sent for basic training, junior basic training, as is required under Rule 3, Roman 4, 405. No? Under Rule 3, Roman 5 of the rules of 1981, or the petitioner was confirmed to the service in terms with Rule 4 of the rules of 1981. Under such circumstances, this court is of the opinion that the appointments so made to the petitioner under such circumstances, this court is of the opinion that on the basis of the appointment letter dated 6/12/1999, this court is not in a position to issue a writ directing the respondent authorities to release the salary to the petitioner from the date of her appointment till the date of her alleged superannuation. In that view of the matter, the instant petition stands dismissed. Can't help you, Mr. Sharma. One thing good, we came to know because of you why they have done this tutor business.
Within all the appointment letters issued by the DEO, Your Lord. All the appointment letters during that period.
That is, all these were wrong appointments which have happened.
But all of them were regularized, Your Lord. What about?
15.
Hello, may I pray for some time? Senior counsel Mr. Das is on lake.
Who?
Didas.
Didas?
He's on lake. Taken up after some time.
Regarding what?
My lord, matter relates to
which department is higher education? Higher education is nowhere to be found. Yes. What is the instructions you have got?
Lordship, here in this matter, Mr. K. Gogoi has asked for the records of the DP, Lordship. Lordship, may I pray for 1 week time, Lordship, let this matter be taken up after a week.
My lord, the situation is now that if, my lord,
Your name?
K. Mohammed.
Mr. K. Mohammed, the learned counsel for the petitioner. Mr. D. Upamanu appears on behalf of the Higher Education Department. This court, by an order dated 29/3/2023, directed the Higher Education Department to obtain instruction as regards the present status of the departmental proceedings. The learned counsel for the Higher Education Department seeks for an accommodation. Accordingly, let this matter be again listed on 10th of May 2023, on which date the counsel for the Higher Education Department shall ensure that the instructions are received as regards the status of the departmental proceedings,
if your
liberty is given to the petitioner to mention the matter for upgrade.
if your lordships allow me, my lord, the departmental
The matter,
proceedings-
I passed the order.
Number 20.
Apart from anything else, my lord, the other day lordships had handed over a copy of this order, my lord. My lord, first of all, my lord, it was a case under Rule 6(2). What was the necessity for, my lord, referring to 6(1)(a), my lord? My lord, there is a way out, my lord. The judgment of Madhurao's India's case, where Supreme Court says, my lord, if a judgment, any observation is made which is out of context, or my lord, which was there when there was no occasion to address that aspect of the matter, then it will not be a binding precedent. There is a judgment by.
Yes, what is the status?
Status, my lord, AP is continuing, my lord. We have stated in our affidavit.
Understood.
My lord, and the inquiry visa has, my lord, short 3 months time. So from there, 15 days is already gone to complete the.
Why 3 months?
My lord, on the last occasion, even the petitioner took time. He did not appear, my lord. It seems from the instruction, my lord.
Have you made a review?
Review we have been made in, my lord, in time, and we have annexed all the documents. Review and the subsequent orders we have made, my lord.
But don't you think that the inquiry proceedings, why is it taking such a long time?
My lord, what happened, I will explain, my lord. Initially, inquiry officer was, my lord, appointed. Then the petitioner raised an objection that officer is from
No,
CID.
that I know. That
So-
on the last occasion it was mentioned. Now recently you have appointed somebody.
Yes, third inquiry.
Yes,
The third one, because the
inquiry.
other two were not those persons
They're
concerned.
my controlling authority, and when the CID PS case was being, they were supervising the investigation.
Now the third one, why does it require from every document is given? What else is required in the inquiry?
My lord, most importantly, in the criminal case, nothing has been found against me. They have not been able to file anything in the court, my lord. They have filed charge sheet, nothing against me, my lord. Only, my lord, their ground of suspicion is, my lord, there's a particular SIM card which was procured by those persons, while Rubul Hazarika, then, my lord, that SP was involved, my lord. Now, actually, what happened? I was the additional SP Karim Dutt, and he was the SP Karim Dutt, that a gentleman called Das. Now, my lord, what happened? There was a SIM card which I was holding, and the SP was holding another SIM card. My lord, what happens in the nearest tower? My lord, both the signals are attracted, my lord. But from the SIM card, which is allegedly to be in my possession, from there, neither there is any record of receiving any call or making any call. It's something like this, my lord. If there is a, tower,
No, Mr. Chaudhary, tell me, you have got the list of witness?
Yes.
They must have given you a list of witnesses. How many witnesses are there?
Once.
In their memorandum?
Once.
Some are still, if I go by affidavit, my lord, some are still in judicial custody.
Yeah.
So we have to, my lord, take permission, appropriate permission and record statement. Those are also things, some complications are there.
No, judicial custody, how will you get it? How can they be a part of the judicial? If it is a court, then you can very well ask them. But do you have the departmental proceedings, have
There are
the authority, have the power?
6 witnesses, my lord. 6.
6. How many witnesses you have examined?
That DP proceeding is not with me, my lord. That I have to get the record.
No. You have to come up with something. You see, Mr. Chaudhary, I have thought about, you see, once, if you see Ajay Chaudhary in between, in paragraph number 22 or 23, 21,
21.
it mention that once the defense is over, till gives his defense, there might be a case of a suspension. After that, the question of suspension does not. That is the only way by which it can be taken out of this difficulty which has come.
Yeah, absolutely, my lord. So, my lord, there are two more aspects, my lord. Now, my lord, here in this case, there was no review within 90 days. And review, my lord, not a perfunctory review. Para 21 of the Ajay Chaudhary, my lord, envisages a review where there has to be a speaking order passed. My lord, because, my lord, end of the day, suspension cannot be an automatic exercise of power. There must be a satisfaction recorded by the authority. That satisfaction could be subjective, but there must be objective materials, my lord, based on which that subjective satisfaction can be arrived at. But question is, my lord, why this requirement of review? Because it is the rule itself which provides. Ajay Chaudhary came, my lord, subsequently. Prior to that also there are judgments of the Supreme Court. Only thing is, my lord, that a fiction has been created by Ajay Chaudhary, which earlier Supreme Court benches never did. Now the effect is, if you do not do this, it will entail that suspension order no longer exists. Now, my lord, where is that review with a speaking order? There is none. Mechanically, even if you do a review, it don't do. Because, my lord,
let us see the review order. Where is it?
Yes. Kindly come to their affidavit which they have filed, my lord. It starts at page number 168, my lord.
The affidavit starts at 168, my lord.
Additional affidavit?
Yes, my lord.
Yes, my lord.
So cause
I think the running page is, it starts at page
statement of
168.
allegations, 6 witnesses.
168, my lord.
I think the first case say, my lord, 192.
Mr. Dhar,
my lord,
these people, Sarosh Sharma, Vishnu Mandal, and Rubul Hazarika,
my lord,
they are in custody.
Yes.
my lord.
Huh?
All are in custody.
And how do you think of completing these proceedings? You are not a court. Disciplinary authority is not a court. He can't direct these persons to appear before him.
Exactly, my lord. That is
Then how can this be completed? How can you say that it can be completed within 3 months if these people are not there? Do you have these are your witnesses. You may have to stall it.
Page 192, my lord. The last para towards the bottom, para 5. It was decided to extend period of suspension in respect of Prasanto Dotto, APS by another 3 months, as draft charges, statement of allegation, etc. have not yet been received. How can that be a ground, my lord?
Where page?
Page 192. It is not
Minutes of the periodical review.
Yes. Last towards the bottom, serial
He
number
said
5.
to extend the period of suspension in respect of Iman by another 3 months as the draft charges, statement of allegation, etc. have not been received.
This itself attracts the first part of para 21 of Ajay Chaudhary.
Now, what is the draft charges?
Draft charges, my lord. Initially, the department, my lord, they forwarded to government, my lord. The draft charges. There, my lord, we have made it part of our.
But, my lord, the order was communicated on 8/11 at page 194. Suspension of, this is beyond 3 months. Suspension of Prasanto Dotto, who was placed under suspension by the department order dated so and so, is hereby continued till 10/12/20. So effectively, my lord, the administrative order whereby the review order was communicated, that is beyond 90 days. The second one is at my lord, page number 195. Serial number 4, again towards the bottom. In view of the Honorable Guwahati High Court's order in WPC number so-and-so, to reinstate the officer, it was decided to prepare a writ appeal against the impugned order. The writ appeal was filed on 1/11/21 and advised by the learned Advocate General. The outcome verdict of the same will still awaited. In the meantime, if Assam Police Headquarters has furnished the report of SP Borpeta in connection with so-and-so regarding involvement of the officer, it was decided to extend the period of suspension in respect of so well, my lord, this is the part. My lord, maybe my lord, the page 195 it contains some reason, but the initial one it does not contain any reason. On the contrary, the reason which they have relied upon, that itself is the reason why it should be reinstated.
One thing, you see, these people are inside.
All are.
Your witnesses, 3 of them. I'm not. How can you think about completion of this in by 3 months or any period? How do you think, is it possible? Until that time, do you think of continuing with him? Has the charge sheet been given in respect to that case, criminal case?
Yes, but my name does not appear, my lord.
Have you brought in by way of an affidavit?
No, my lord, but it is a fact, my lord. We have made a statement. He has not been charged. In the writ petition, we have mentioned.
No, you see, if it is uncertain that it cannot be completed, can you continue? Would it not affect his rights under Article 21?
Okay.
I would have understood normally, but the moment you have said that these people are in custody, it is impossible for you. If it is this court being the elementary, this court being the authority, this court can very well direct, then let him be produced. I will have but the disciplinary, the inquiry officer would not have the power. I don't think under the rule 9 that power is given.
On this, my lord, let me get an instruction, my lord. Suppose, my lord, that the very first argument that my learned singer has, my lord, provided that the very first thing, review, we don't do it in time. We have an, my lord, explanation.
It's okay. Review, you see, you can't complete the review. You are saying extending the review every 3 months, although as per your manual, it is 6 months. Ajay Chaudhary does not say for a review 3 months, but as per your manual, it is 6 months. But that review, which is to be done as per your office memorandum dated 4/2/2020 or 21.
Yes.
Every 3 months, you have to give a periodical report to the Chief Secretary. If you look into that. So under such circumstances, is it conceivable or can you conceive that it would be finished within this year also? Because normally it's okay if you have only the witnesses 1, 2, and 3, but you need the 4, 5, and 6 to prove your case. But can you prove your case if these people are in custody? And do you have the power? Let us assume another thing. Do you have the power to summon a witness? Forget about other things. Do you have the power to summon the witness?
As CPC provides.
Huh?
As CPC provides.
Do you have that power? If you don't have the power, can you call any independent person unless he is willing to come and help you? This is a thing to ponder. That power is not being given to the disciplinary authority.
And it has to be conferred by the statute. That's why, my lord, for example, administrative tribunals, they are given the power of the CPC specifically. That's the limited power.
So you calling for anybody else, those three persons, not only they are in judicial custody, but you have the power to summon them. If you don't have the power to summon them, wouldn't that be, and you are sticking to have these 6 witnesses. For all times to come, it will be a never ending.
And I can be transferred out, my lord, so that I do not play any role.
My lord will fix the matter next week. I will get an instruction, my lord. And next week, my lord will keep it for disposal. Even
think on that,
yes,
because that is a very important aspect.
I know my limitations, my lord.
You know your limitations. And Mr. Chaudhary, ask your junior to file an affidavit bringing on record that charge sheet.
Yes.
Because then it will help this court
Yes,
to pass the order. It is there on record.
1 second. Yeah, it is there, my lord. Sorry, I'm sorry. Page 33 of the writ petition.
Page 33. This is the final report. Yes. Your name is what? Prasanna Datta.
Prasanna Datta.
His name is there with the liquor baron.
That hotel in GS Road.
Huh?
That hotel in GS Road.
So his name is not here.
Not yet.
Not an accused. So it is okay. Then in that case, you get your thing. When next? This Friday? Next Friday?
Yes.
Next Friday. What?
You said 1 week.
Oh, Friday is a holiday. Can it be Thursday, madam?
Okay.
My lord, again, Monday is a holiday also.
Oh,
I have to get the instructions, my lord.
We'll then have it on 8.
Fine.
You get your instruction to the effect. Huh? Because you see, you don't have the power. And it will be an unending thing. And I think, Mr. Chaudhary, the only way is Article 21.
Exactly, my lord. Only way out.
Huh? Mr. K.N. Chaudhary, the learned senior counsel, assisted by Mr. J. Batwari and Mr. Ardhod, the learned counsel, appearing on behalf of the respondents. This court had put a pointed query upon the learned counsel appearing on behalf of the respondents as to what is the status of the departmental inquiry. The learned counsel for the respondent submits that the inquiry or new inquiry officer has been appointed, and there is and as per his instructions, the said inquiry officer has stated that he could be completing the inquiry within a period of 3 months, and of which 15 days have already gone. This court, further taking into account Annexure 1 of the additional affidavit so filed by the petitioner respondents, which is the memorandum of charge / the show cause dated 24/11/2021, and the list of witnesses mentioned therein. Further inquired with the learned counsel for the respondent as to whether the witnesses on behalf of the department have been examined. The learned counsel for the respondent submitted that out of the 6 witnesses mentioned therein, the witnesses at serial number 4, 5, and 6, isn't it, Mr. Dhar, are in the custody.
I think my lord 3 also. 1 and 2 other than.
Superintendent of Police also, earlier.
Yes,
Kumar Sandhu
yes,
Krishna.
yes, he's the main man.
The respondent number 3, 4, the
Only
witness
1 and
number
2
at
not.
serial number 3, 4, 5, and 6 are presently at judicial custody. In that view of the matter, this court inquired with the learned counsel for the respondent as to how the inquiry officer can conceive of completing the inquiry when the witness at 3, 4, 5, and 6 are in judicial custody, and as to whether the inquiry officer would have the power to summon the said persons, said witnesses, for the purpose of completion of the inquiry, for the purpose of examination of them as witness. The learned counsel appearing on behalf of the respondent submits that he requires an accommodation for a week so that he can obtain the instructions in that regard. List the matter again on 8th of May 2023 at 2 p.m. on which state the learned counsel appearing on behalf of the respondent shall apprise this court as regards the inquiry as regards the questions so raised in as mentioned herein.
If
29.
Oh, that matter.
My lord, it
You
will
got
be
it?
credited on 26.
You got your payment?
Right.
Very good. Last, something good has happened. So we close it. So many orders being passed. Where is Mr. Rahul Dhar? Gone. Miss M. Das, the learned counsel for the petitioner. Mr. G. Jalan, the
Respondent number
learned
6.
counsel appearing on behalf of the respondent number 6. Mr. S.R. Burwa appearing on behalf of the director of pension. And Mr. No, Mr. Dhar, just 1 minute. And Mr. Finance A. Solia appearing on behalf of the finance department, who represents the Treasury Officer Noga. The learned counsel appearing on behalf of the petitioner has submitted that she has now received the family pension. And as such, she does not want to press the petition. Taking into account the same, the matter stands closed. Is that all? 2 matters. Pension. This at last got closed. 1 matter was there, which I have made you the amicus. Where he is there? No.
No. Here, my delay has only caused.
Huh?
Here, delay has caused because only in the year 2015 the pensioner died, and in 2022 they obtained the death certificate.
Understood, but these are things which
Yes,
they don't know. Now, most
is
of the
difficult.
people, they don't know. Now, that is why this regulation of this giving this life certificate has become much easier.
Yes, sir.
And in fact, there should be something law of what we have in this education thing. Nah? Education volunteers. I think you should also have pension volunteers. That a person, if he does not give a life certificate, inquiry should be made as to why. If the government does have a role, then this area, you see, giving an area is also a big thing for the government. At one go to pay such a huge amount. Yes. 30.
Lordship, in this case, retirement, Lordship,
certain amount is due to the petitioner, Your Lordship. He didn't receive his
Shall
salary,
apprise as to
subsistence
whether the
allowances.
final payment of GPF have already been made to the petitioner or not. Further to that, the accountant on so and so shall apprise the court as regards the relief of the leave encashment. What has happened?
Yes, Lordship. Regarding GIS, Lordship, the petitioner has not applied, Lordship. As for GIS, Lordship, a particular format is there. It is Form 3, Lordship, and Form 3 is required to acknowledgement from the Treasury officer concerned, who were in the earlier posting, where he was in his earlier posting, Lordship, regarding the deduction of his from salary. From his salary, Lordship, and therefore the Form 3, as and when the petitioner will submit Form 3, Lordship, he applied, then the department will release
that. Yes.
Yes, Lordship.
Okay. Now, what about the subsistence allowance?
Lordship, appraisal for GIS only, Lordship.
The payment of the subsistence
earlier
allowance
to
to
be
the petitioner until further orders and the enhanced payment is subject. Pension has been receiving the provisional pension. On the other hand, Mr. So-and-so, the instruction submitted has not received any subsistence allowance. However, she has no idea whether the petitioner has submitted the certificate as required under the Hey, what is your instruction as regards the certificate? What?
Lordship,
What is your instruction as regards the certificate of under FR 53.2?
Lordship, my client could not give that answer, but he did not receive any subsistence allowance.
Understood. Did you
Yes.
submit the certificate under FR
for-
53.2?
As for by them, I have submitted to my instruction, my lord.
No,
Whatever they
no.
have
You see,
submitted.
together with your instruction, have you taken a copy of this order or not on the last occasion? Do you have a copy of my last order?
Yes, yes, sir.
See, then, on the other hand, Miss B. Bhuya, the senior counsel submitted as per her instructions submitted, had not received any subsistence allowance. However, she has no instruction as to whether the petitioner has submitted the certificate as required under 53.2 of the FRSR. Have you taken that instruction?
Lordship, he did not submit that. He did not submit that.
So how can he get his subsistence allowance unless he submits that? Then the accountant general shall apprise this court as to whether the final payment of GPF have already made. Have you got the GPF?
Nothing, your lordship.
We have not received the proposal.
Huh?
And my lord, once we receive
Have already been made. Further to that, the appearing on behalf shall also apprise the court as regards the release of the leave encashment.
regarding leave encashment, my lord, we have written to the, my lord, this is the letter of 2018, my lord. We have written to the Deputy Secretary of Personnel Department that the suspension period that has not been regularized, my lord. That's why, my lord, we could not,
That is long time back.
my lord.
5 years long period thing you are bringing it before this court.
That period till today that has not been regularized, my lord.
Leave that suspension period.
My lord.
Now what has happened to the suspension?
Lordship, I was reinstated from service. Lordship, and then thereafter I have retired.
What about the departmental proceedings?
It's they will give the status.
No, you
They
are not
say-
aware.
No, Lordship, because they say that they have issued a show cause notice. It was indeed issued to me, my lord. Then thereafter nothing, my lord.
Have they issued the show cause?
Yes, it is
And
there
you-
in the order itself, your lordship.
Departmental proceedings is pending, Lord.
It's pending.
Yes, it's reflected in the reinstatement order.
Departmental
And
proceedings for what?
the allegation is that I have received bribe,
Oh.
but it was resulted in lordship discharge, my lord.
It's okay, but
Discharge from the criminal case,
But
my lord.
for criminal
prove
and departmental proceeding is different. But when are you going to complete it? Because he has not got your pension. Have you got your pension?
Provisional I'm getting, my
Then the other things he has not got. You need to complete it because the DCRG is an amount which they can't get it unless you complete that. When?
My lord, in that letter, my lord, the last part, my lord, the prior to his
Mr. Hassan, I'm not going to see a 2018 letter. You have to be up to date.
lordship, it was initiated on 30/10/2017.
Which one?
NHD page 32 DP. By Shoku's notice the 30/10/2017.
Leave encashment not given because of that regularization. That I understood, but that regularization can't happen unless they complete the DP.
DP, my lord.
And the DP they are not willing to complete. When did you retire?
I retired, your lordship, retired 36/18. 36 2018.
18 they retired and till now DP is still going on.
So
My
far,
goodness.
So far, my instruction also at present instruction, the DP is going.
Mr. Goswami, why don't you ask that what am I going to tell when the court asks me how a DP can go on for 5 years? Why your instruction is something in a more mechanical manner? Must be because of the fact that you are also asking it in a mechanical manner.
Lordship, the status of the regarding the DP, Lordship, I will apply this court. Lordship.
No, that has to be completed.
Yes, Lord.
Because you see, the leave encashment has not been given because of the DP, the suspension period. Now you, how long was the suspension?
Lordship,
Suspended, my lord, with effect from 14/9/2017.
suspended 49/17, reinstated on 29/6/18, and retired on 36/18.
For 2 years.
Yes.
Okay. Now, can't he get a provisional DCRG? You give provisional DCRG as per your office memorandum of the personnel department. You see, there are two things which are being given. One is a provisional pension and a provisional DCRG. Only thing is the final DCRG is not being given, isn't it? The office memorandum of 2013.
The provisional provident fund, Lordship, DPF, in respect of the petitioner, Lordship, are not withheld by the government of Assam. It is, Lordship, the Accountant General has been already communicated with a white letter dated so and so for final payment of GPF. Sir Binod, the petitioner has not yet made any application for release of leave encashment. That is the issue.
Instruction dated?
Yes, I
Which
have the
date? Please apprise the
yes instruction.
Yeah.
It is
No,
21
I will record it.
2023.
I will record the instruction in my order.
In the
Yes.
earlier order,
It may be
Lordship,
recorded.
this Lord,
It
your
may be
Lordship
recorded.
recorded.
This instruction.
So, as regards the subsistence allowance, you don't have instruction as to whether the form has been submitted in terms with FR 52. You have no instruction. As regards the DCRG, it has not been done. Are you putting any obstacle on that?
No,
DCRG?
no, Lordship. No, Lordship.
They should get it.
No,
That, how will he get it unless you regularize that period, which you are not, unless you complete the departmental proceedings?
This year.
But Madam Bhuya, kindly appreciate one thing. This court is giving an importance to the matter, but it seems that you are not interested.
No, your lordship.
No, why
My
haven't you
client,
taken? Why haven't you taken the instruction to the effect?
Lordship.
My order was clear to the
Yes,
effect.
yes,
Why haven't you
I
taken any
understand your
instruction?
lordship. But my client did not give any rational answer to the query.
If he
made
doesn't
by
give
me,
a
your
rational
lordship.
answer, why should this court give it
Lordship,
importance? There are many other matters which are waiting.
Lordship, may I pray, your lordship, this matter may be taken in the coming week.
Okay. Well, let the matter be listed after 2 weeks. Get your instructions. I'm not going to pass any order. You see, I give importance to these matters because of the fact that it is urgent. But if you don't give importance, it is as if the court is taking importance. On which date the learned counsel for the petitioner as well as the learned counsel for the petitioner shall obtain the instruction as recorded in the earlier order dated according to 23 2023 last order 23 3 no? Whether to get the learned counsel appearing on behalf of the which department?
Lordship, personnel department, Lordship.
Of the
2, 3,
personnel
and 6.
department shall also apply as to what is the present status of the departmental proceedings so initiated against the petitioner.
Regarding GIS,
And further to that, the learning counsel for the petitioner respond. You just find out what is the status of the two. no liberty to mention. So it will go for a 6.
Thirty-two.
You may kindly change the last order dated 1/3. Provisional pension was directed to be given.
You got it?
No, Lord.
Which department?
Health department.
Yes, Mr. B. Gogoi.
My lord, that updated instruction, my lord, can it be next week? After this long period, my lord, I couldn't have the updated instruction. But GIS has been paid, my lord. But provisional pension, my lord, probably not been
Provisional
paid.
pension has to be paid immediately.
Yes, of course.
Then why haven't you paid that? And there is a
That, my lord,
direction.
Lordship will take up on my lord Monday. In that case, I will have time.
This court finds no reason as to why the petitioner shall not be paid the forfeit along with the DCRG. However, made clear that in case there is any pending judicial or departmental inquiry, then in that case the requirement of pay shall not arise.
My lord, there is a departmental proceeding was there, my lord, in case of the petition.
It is there or completed?
He has retired, my lord. There also I can't say as of now. But
Lordship, as per my instruction, Lordship, it was completed and she was exonerated of all the charges.
You must have enclosed some document. Exoneration does not happen like this in today's matter. I was taking up somebody verbally informing or telephonically informing that look here, this we have exonerated you. Does it happen in that manner? Then why haven't you enclosed? That is your instruction.
I have made a statement in paragraph.
No. Why statement business? Isn't the document given or is it telephonically informed?
Lordship, I'll seek the document. If required, I'll file an additional.
We fix it on 15th of May.
well,
In the meantime, you get your instruction and as regards the provisional pension, whether it has been paid or not, and you file an additional affidavit as regards this. Surprisingly, why you think that I file and put it on affidavit? Isn't it required? Have you seen the judgment of the Supreme Court in the year 1987? It categorically mentions, you must read the judgment. There's a difference between a civil suit as well as the pleadings in civil suit and a pleadings in a writ petition. If it is a pleading in a writ petition, you are not only going to state the facts, but also the evidence. What is your evidence? You want the petitioner to be cross-examined? We'll ask the petitioner to come then.
But she received.
If it is a documentary evidence, then why that document? And more particularly, if we look into the Evidence Act out here, Section 91, if it is a documentary evidence and it is only on a documentary evidence this can be proved, then it has to be the documentary evidence which has to be placed before this court. Why have you mentioned it only by way of an oath? Let's have the petition on the next date.
No, Lordship.
Yes, we'll have a particular box to cross-examine. Mr. Gogoi, you cross-examine the petitioner on this aspect as to whether.
I will come up with an
He was not given that exoneration, Lordship, but then the
That means it has not been exonerated. The departmental proceedings has to come to an end by way of an order. Then why did you make a false statement?
only to the extent that the inquiry report was given and that in that inquiry report, therein, Lordship, the charges were not held against her. That much was.
Then is the inquiry report was given must be to you?
Maybe, Lord. I'll have to obtain that.
You must have inquired also prior to your retirement what has happened to your departmental proceedings, and if more particularly if he has gone in your favor, then. Heard Mr. MP Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the Health Department. Mr. A. Hassan appears on behalf of the Accountant General AE. This court, by the order dated 1/3/2023, have directed the respondent authorities to release the provisional pension as well as the DCRG. It was further mandated that if there is any pending judicial proceeding, judicial or departmental proceedings, then the question of payment of the DCRG does not arise. Mr. B. Gogoi, learned counsel appearing on behalf of the Health Department, however, have submitted that to his instruction there was a departmental proceeding. However, Mr. MP Sharma, the learned counsel appearing on behalf of the petitioner, submits that there was departmental proceedings, but the petitioner has been exonerated. However, from a perusal of the writ petition, there is no documents enclosed to show that the petitioner have been exonerated. The learned counsel for the petitioner submits that he will file an additional affidavit bringing on record such documents, thereby exonerating the petitioner from the departmental proceedings. Mr. B. Gogoi shall also apprise this court as to whether the provisional pension, as directed by the order dated 1/3/2023, has been duly complied with, has been duly paid in compliance thereof. This is the matter again on 15th of May for further consideration.
Lordship, may I say one thing? Lordship? At paragraph 7, I have only stated that I have an inquiry report, Lordship, which was received by me, not the final exoneration, Lordship. Only one inquiry report was given to me. That much was stated by me.
Then you have said that you have been exonerated. Didn't you say that?
In the inquiry that was done, Lordship, but then after that, how the departmental proceeding proceeded, Lordship, I don't have any instruction of that.
Why did you say that you have been
In
exonerated?
the inquiry report, I'm sorry to that effect.
Be careful when you make your submission. You said that you have been exonerated.
I'm sorry to that.
It will shall bring on record such documents which will show that the departmental proceedings have ended into an inquiry report in favor of the petitioner.
34.
Yes, Mr. Khan.
On the last question, your lordship has directed to obtain instruction regarding the entitlement of the petitioner.
Yes, Madam Bora, you paid the provisional pension?
Let's say we are waiting for the instruction.
Huh?
Waiting for instruction, so in this regard.
Why?
They were not up to date instructions not received. In this
Madam, there is only one order. How can there be a question of up to date or any? There has to be only one instruction. This court have asked as to whether you have paid the provisional pension or not.
No, not paid.
Then why not? Why haven't you paid the provisional pension? We fix it on 3rd May. Get your instructions, or if nobody appears, then we'll have the. Who is this? Which department is this?
Well, this is Panchayat.
Huh?
Yeah, no, lordship.
Regional pension you have not paid. Panchayat and rural development. Get hold of the commissioner on the next occasion. Heard Mr. M. Khan, the learned counsel appearing on behalf of the petitioner. Ms. N. Bora appears on behalf of the respondent number 1, 3, 4, and 8. Mr. R. Pujari appears for the respondent number 2 and 7, and Mr. J.K. Goswami appears for the respondent number 5 and 6. The learned counsel appearing on behalf of the Panchayat and Rural Development Department admits that she has no instruction pursuant to the order dated 23/2023. It surprises this court that this court had only asked the learned counsel to apprise this court as regards as to whether the provisional pension as to whether the petitioner was entitled to the provisional pension. Be that as it may, this court fixes this matter again on 3/5/2023, on which date The Learning Council for the Panchayat and Rural Development Department shall apprise this court as to whether the petitioner is entitled to provisional pension or not. It is made clear that if no instructions are received by then, this court would have no other option but to pass appropriate orders seeking compliance to the orders passed herein.
35 and 36.
Please, your lordship. My lord, 35 and 36 are two different matter, my lord. I am not in 35.
I mean 35.
You are not in Govinda Rajabangshi?
No, on that matter, I am not representing him. In next matter, I represent him.
Fantastic.
And it is tagged together because of submission by the learned standing council, my lord.
Oh, name are same.
Name are same.
My lord, same person,
Same
my lord.
person, my lord.
Same person, my lord.
Person is same, but because of it,
What is this 35 for? 30 your matter for? What is your matter for?
my matter is, my lord, he was suspended for long, my lord, and in the meantime, he has retired, my lord, but no action has been taken, my lord. It is suspension order, no departmental proceeding, nothing.
So that is the matter. What are you challenging here?
My lord, here, my lord, I will take your lordship.
More particular to allow the other to join his duties immediately after giving his joining report that goes.
My lord, I will take
Memorandum
your
shall
lordship.
not be issued directing to release the outstanding salary of the petitioner that remains. These are the two. You want the salary.
No, not that, my lord. My lord, here, my lord, I will take your lordship, item 36, my lord. I will take your lordship to Annex 2. He was suspended. He was put under suspension, my lord. That suspension order was my lord, modified, and thereafter the suspension order was revoked, my lord. And after revocation of the suspension order, my lord, I applied for, my lord, to join my service, but that was not allowed. That is my case.
No, that does not any further does that this aspect does not remain any further for you to join. You have already retired.
No, my lord, that is there, my lord. And my
So your first prayer has become useless.
yes, my lord. That
Now
is
the second prayer remains
Yes.
as regards your outstanding dues.
Outstanding dues, my lord, for 12/6/2019 to 38/9/2021.
Understood. So you want this outstanding dues.
Only that.
So why don't both I assimilate both the matters, because
Yeah, on the
then
last-
you get your relief also.
No, my
Don't you
lord,
want
my
that
lord,
relief,
they are
or you
petition-
want the relief independent?
No, that is, my lord, that is a completely different cause of action, my lord. In that case, my lord,
Madam, I understand that.
yes, it is.
You want the salary
Yes.
for that.
For our
Isn't it the same person?
on
And
the-
in this second petition, he is asking for his pension.
my difficulty is, my lord, this is filed by two persons, my lord, and on this, my lord, I have no.
The lawyer is different.
Lawyer is different.
I'm not on the lawyer. Lawyer, I'll get hold of him for the second matter.
Otherwise,
But if both the matters are taken together, it is helpful for both of you.
Yes, that is
Then
was- yes.
should the fight between the lawyers be the ground for not giving the benefit to the
No,
petitioner,
that-
who
that-
happens to be the same?
That your lordship may do.
Yeah, that is what I'm wondering. The case of the petitioner herein is the petitioner has not been paid the arrears salary of an amount of rupees 1,73,000 and so to the petitioner respectively.
Yes.
Why it is same is this? This is the arrears salary which has been asked for in your petition.
Yes.
My outstanding amount is earned leave. It was earned leave for a particular period.
There are two amounts
There are two petitioners.
and there one petitioner.
Yeah, one petitioner, my lord. Only
Item
Guru,
number 36, there is
one petitioner.
Why are there two petitioners here?
there.
Why the cause of action? The cause of action of each petitioner would be absolutely different.
Different, my lord.
Common order has been passed. Common order has been passed.
Maybe common order has been passed, but how can both have the same cause of action? Tell me.
From the very beginning, we were representing we were filing common representation.
You have given all these things are different, but the right to get your salary or your outstanding is completely different from a right of salary by another person. Don't you think so?
Yes.
Then?
Since My case is that since from very beginning we are filing common representation and a very common order, it has been denied to us that due to the poor financial condition of the corporation is unable to pay us. Same order. That is.
Who is appearing for the Plantation Corporation Limited?
My lord, I am appearing, my lord.
Fantastic.
My lord, I need instruction, my lord, because the MD, my lord, her mother-in-law expired yesterday, my lord. So I need 2 weeks time, my lord.
So why were you waiting for the last moment till yesterday? What was his mother-in-law didn't expire the day before yesterday? This order was passed on 2023.
Yes, my lord.
Then?
But my lord, I awaited instruction, my lord. I need 2 weeks time, my lord.
And what about the earlier matter of Ms. Bachaji?
Yes, my lord. That affidavit I have filed, my lord.
What is it? He is not entitled to?
My lord, that departmental proceeding, my lord, in my affidavit, my lord, there are 2 affidavit, my lord, filed by the FDCDC, my lord. And the board had directed to
what is the affidavit file?
File on 16/1/2022, my lord. That is as additional affidavit, my lord.
Yes.
And that affidavit, my lord, para 3, my lord.
Additional affidavit.
No, additional affidavit, my lord.
Filed on 16/2/2022.
22, my lord. Yes.
What is it?
Here, my lord, on 18/11/2022.
Para
3, my lord.
Yes.
As per board meeting dated 5/4/2022, page 44, my lord. Running page 44, running page, my lord.
And decided that the criminal proceedings shall be drawn against the petitioner with regard to the demand of bribe to the tune of 993.22 lakhs for releasing the outstanding salary, which was sanctioned by the government as one-time favor in favor of so-and-so. As further requested, the necessary action may be taken against the petitioner. What is this English? The petitioner has further requested that necessary action may be taken against the petitioner.
My lord, that CM Vigilance, my lord, that FIR was registered against the petitioner, my lord.
Let us read paragraph 3 from the beginning. Let us understand what is it. That the answering deponent begs to state by the first information report dated so-and-so, the answering deponent have informed the Superintendent of Police, Office of the Directorate of Vigilance and Anti-Corruption, Assam, that as per the board's meeting dated so-and-so, it was decided that the criminal proceedings shall be drawn against the petitioner with respect to the demand of bribe to the tune of 993.22 lakhs for releasing the outstanding salary. You mean to say that the petitioner sought for a bribe of 10 crores?
Yes, my lord.
My God. Which was sanctioned by the governor as a one-time grant in favor of so-and-so. The petitioner, I think the sanction was only given for, let us see the FIR. Where is the FIR? We have enclosed it as
Annexure J, my link page.
54.
64.
64. In the last BOT meeting, it has been decided to drop criminal proceedings against the regarding demand of the bribe against releasing of outstanding salary for an amount of demand. They are written wrongly. Here, the demand of a bribe was taken for the purpose of releasing 10 crores. That is it, what is meant, and you have mentioned that he has asked for 10 crores as the right. Isn't it?
My lord, that is the allegation, my lord.
Allegation also is that only.
Yes, my lord.
That
then, my
or
lord,
regarding demand of the bribe against releasing of outstanding salary to the employees of so-and-so for an amount of rupees 10 crore, which was sanctioned by the governor as so-and-so. The resolution recorded in so-and-so, hereby authorized to initiate prosecution, criminal proceedings against here. In view of the FIR against so-and-so is submitted before here. Where's the FIR?
FIR, my lord, this is the FIR they have submitted, MD have submitted before the, my lord, Superintendent of Police, my lord. But till then, my lord, they have not registered the case, my lord.
Obviously, why will it be registered? You say, in view of the above, FIR against so-and-so is submitted. Where is the FIR?
My lord, this is the affair according to them, my lord. That is the letter they have submitted.
Now, thereafter, what happened? Obviously, they won.
And my lord,
And why haven't you given to the officer in charge? You are given to the superintendent of police,
my lord,
director of
because my
vigilance
lord,
and
board meeting,
anti-corruption.
my lord, it was held, my lord.
Okay, then what happened?
My
The
lord,
same FIR repair was received by the additional copy. So as of now, there is no FIR. There is an FIR,
Yes.
but it has not
Not
yet been
registered.
cleared. So there is no judicial proceedings
Yes.
against the petitioner. Now, as regards departmental proceedings, what happened?
My lord, that I have asked, my lord, that they said that there is no any record, my lord.
There is no departmental proceedings also.
My lord, they have said that they have conducted departmental proceedings, but they have not, there is no availability of that record, my lord, as per their version, my lord.
So there is nothing left.
Yes.
So under such circumstances, no departmental proceedings, no judicial proceedings, then why the petitioner is not entitled to the dues?
That is, my lord, yes, my lord. But I have repeatedly asked them, but they said that there is no any record, my lord.
Understood. Madam, you have done your bit, but if the respondent number 5 is not helping, how you can't help them, no?
Yes, my lord. Next week, my lord, this both matter, my lord. My lord, after 2 weeks, my lord.
And you choose one of them amongst both, one of them. Both are having different aspects. Both have different cause of action. Area salary, then why not join all the petitions together out here and file one petition that all these, against all these departments, we want the pension? Get hold of all the petitioners together, file one petition. It will be easier for this court also. Only one matter is listed in the court.
Lordship, my case is that, Lordship, we are working in the same department. We were filing common representation, and by the same impugn order, we have been deprived.
And in this case, what has happened? This is an area salary of the petitioner number 1 pertaining to which period?
Yes, will be reflected from page number 17 of my petition. Page number 18 is the area of petition number 2.
Madam, your period for area salary is from 22 2011 to 6/3 2012. What is your period for area salary?
It is for 12/6/2019 to 30/9/2021. Because, my lord, I was suspended. That suspend order was before. I did not allow to join, my lord. And thereafter, in the meantime, on 30/9/21, I retired from service.
You resigned.
No, I superannuation. I retired at an age of retirement. So my period is 12/6/2019 to 30/9/2021. That is for 2 years, 3 months, 18 days, and it comes to 2,10,000.
2 lakhs.
2,10,000. That is my case.
But there is one amount of which has been mentioned, statement showing the unpaid salary period, gross amount and the net amount. From 22/2011 to 6/3/2012, total amount is 1,73,070. This is prior to your filing of the writ petition. This is acknowledged by, this is a document which have been submitted by your petitioner. This is the only area salary he is asking for, as given in the year 2022.
In item 34. 35.
35, that is the document that he is only asking for an area CA for this period only, nothing else.
And that matter I am not aware of, my lord.
Show him from your petition, page 21.
This is the period.
Understood, wait. Page 21, you say that the name of the victimization of the, here, you see, most respectfully and in inviting the reference to the subject above, we following signatories of so-and-so under the administrative control of the so-and-so do hereby most regretfully inform your honor that we are yet to receive outstanding salaries for the respective periods as detailed below. So this is irrespective of nothing else. It's categorically mentioned that this is only the period for which he is asking for.
For earned leave, my lord, that is denied. That amount.
Earned leave couldn't have been there at that point of time. You see, 22/2011 to 6/3/2012. Meaning thereby the period for which you are asking, he must have got it. Because this is given in 2022. He is not saying only on the earned leave. You see, kindly see thereafter. Kindly go to the contents of the petition dated and so submitted by Govinda Rajbangshi, the then senior so-and-so, as per the office order dated so-and-so, the accounts prepared the outstanding salary bill and his gross unpaid salary of the said comes to rupees 1,85,000, and after deducting all deduction, the net salary comes to 1,73,000, which is not paid by the APDCL to so-and-so, the APC till date, only on the plea of financial crisis, no fund, paisa nahi, etc. So-and-so has now retired from his service as office so-and-so without receiving the said unpaid salary.
Period is from 2011 to 2012, my lord.
Absolutely. So this is what he is being asking for.
But our case is slightly different.
No.
Because
Then why in his last of the representations have only stated that this is the only amount payable? He has not said anything about the earlier case or anything.
That is why I am little bit surprised, my lord, because I am not aware of this development, my lord, on last.
I think you should take instructions in that regard, because whether it is the only amount, if this is the only amount which is there, and this is also been approved by the authorities, and the authorities have said that we are not in a position to pay, not on the total amount comes to, if you see that petition itself, the total amount comes to at page 21, 5,34,268. Page 21. 5,34,268. And if you see then at page 25, this is what the managing director says, that this amount of rupees 5,34,268, which is to be paid to you, we are not in a position to pay because we don't have money. And it is because of that he has filed a writ petition. Now, if this is the only amount due, then where is the question of any other things? Because if you see, for at page 22, earned leave is for only for this person, such as it's Sen. Earned leave is not for this person, Govinda Rajbangshi. Only for Satyajit Sen it is earned leave. Page 22. Heard Miss A. Bhagatchaji, A. Bhagatchaji, the learned counsel appearing on behalf.
Permits me, your lordship permits me. My lord, I will take your lordship to the facts of the case in brief, my lord. Because, on last occasion, my lord, when the matter came up before your lordship, my lord, that is on 23/9/2001, my lord. That is your lordship say.
23.
On 23/9/2001, last paragraph, my lord. Under council, soil conservation department is directed to obtain the instruction regarding latest development of such criminal proceeding and the connection of the present petitioner with the same. List the case after ensuing to the petition. And thereafter,
Madam, when did you retire?
on on 30th/9/2021.
19/9/2021.
21.
And did you initiate the proceedings prior to the departmental proceedings?
My lord, there is no any record, my lord.
So they don't know. So as on 23/9/2021, if they are to initiate any proceedings, whether the Assam service pension rules apply,
Some service will know, my lord.
it does not apply.
My lord, I will take instruction.
And thereafter, I will take your lordship to another fax, my lord. That is your lordship order, my lord, list the matter on 30th/5/2022. And on 30th/5/2022, they took time for instruction, my lord. And thereafter,
Where is
my lord,
Mr. B. Gogoi? Oh, yes, you are there for this soil conservation.
No, my lord, I am a representative soil conservation.
You are representing for that
Yes.
corporation and soil conservation.
Yes, my lord.
Now, you have no records as regards the criminal proceedings.
No, my lord, no, no.
Then you have not done anything.
No, my lord, because my lord,
And what is the amount she is entitled to? He is entitled to.
that is my lord,
As per this petition, that is also not mentioned.
my lord, I have to take instruction, my lord, and the petitioner is not a
Instructions,
government
filing
employee.
affidavits, after affidavits, then additional affidavits. But we are not getting to the crux of the point, because here the writ petition is limited only to area salary. This is also a writ petition pertaining to area salary. Both are area salary. In the last of the representation, he says that he is only entitled to 1,73,000, and that too for a different period, and this is for another different period. Both of you get your instructions
if your
corrected.
lordship
My lord,
permits me,
after 2 weeks.
Or Mr.
if your lordship permits me, my lord, I will take your lordship to the, after your lordship direction, my lord, they have filed an affidavit in opposition, my lord, on 1/12/2022. And I will take your lordship to page 59. That is the resolution.
No, madam, why I am saying it, I think both of you need to take your instruction as to what is the amount due. The last of the representation which is being submitted as regards area salary for Govindo Rajbanshi, I'm not concerned with the other person. This other person's writ petition should be dismissed on the threshold. He has to file a separate one. But as regards Govindo Rajbanshi, there is area salary which he's claiming is only for a different period, which is not what you are claiming. I think you need to take your instructions for that. But Ms. A. Bhattacharya, because your only prayer remains is for area salary, nothing else. And his is also for area salary, nothing else. So why there are different periods for that? Heard Ms. A. Bhattacharya, the learned counsel, appearing on behalf of the petitioner. And your name?
P. Bora.
P. Bora appears on behalf of the respondent number. Petitioner in WPC number 1557 of 2023. I will take it appear on for WPC number 2388/2000. Ms. R.B. Bora?
R.S. Deori, my lord.
R.S. Deori appears on behalf of the Soil Conservation Department as well as
Assam
the
Plantation Corporation.
Assam
Plantation Corps Development
Corporation.
I appear for finance.
A perusal of both the writ petitions shows that while in WPC number 2388/2020, the petitioner therein has only prayer, only relief which can be granted is a prayer for area salary. On the other hand, in WPC number 1557/2023, the petitioner number 1, who is the petitioner in WPC number 2388/2020, claims an amount of rupees 1,85,646 as the area salary for 2/22/2011 and 2/6/3/2012, and nothing more than that. This court therefore fixes this matter again on 24th of May 2023. In the meantime, the learned counsels for the petitioners shall obtain their instructions as to what is the exact salary they are claiming for, and as well as Ms. R.S. Devi, the learned counsel appearing on behalf of the respondent department shall also apprise this court as to whether there is any departmental proceedings or judicial proceedings initiated against the petitioner.
I appear for financial item 35, the first petition.
May I take it, Lordship?
Yes, madam.
Lordship, I need some further time to obtain instruction, Lordship.
Mr. S.R. Borua, the learned counsel appearing on behalf of the Director of Pension submits that he requires some accommodation in the matter to obtain the instructions in terms with the order dated 24/3/2023. Accordingly, lists this matter again on 22nd of May 2023, on which date the Director of Pension, on which date the learned counsel appearing on behalf of the Director of Pension shall apprise this court without fail in terms with the instructions sought for by the order dated 24/3/2023.
Obligation. Lordship, here in this case, Lordship, the learned additional senior government advocate P.T. Sutia will is supposed to be apprised before this court, Lordship. But at the same time, he is suffering some illness.
Who?
This is Sutia, Lordship.
I saw him.
Yes, Lordship. He was here in the first half, Lordship. During after that, he will suffering from blood pressure problem, high blood pressure, Lordship.
Then,
kindly,
and he didn't confide with you the instructions?
Like he was not pick up his he's not pick up my telephone, Lordship. Cell phone, Lordship. He's suffering, Lordship. Kindly pass over the matter for today's, Lordship. He will approach.
I will hold it. I'll give it. I'll fix it on 22nd of May. I'm not concerned as to who appears.
Lordship.
We are concerned with the government advocate.
I will come.
Whoever it is, I'm not concerned with next time onwards, as you are submitting, as because of here I have put Mr. T.C. Sutia's name, that means he has to get instructions. I'm not concerned to that effect. Next time I'm not going to put the name of any government advocate.
No,
I'm not going to put the name of a government advocate in the order, because this is, if I put it, then this happens. I'm not concerned to that effect. Here is a case of a family pension. A person who has died in the year 2019, 4 years have passed by, nothing is there.
Yeah.
Then,
can you fix the matter any date in the next week also?
Next week.
Yes.
But Mr. M. Soikia, the learned counsel appearing on behalf of the petitioner. Mr. You put your name?
Yes, Lordship. Yes. Yes, sir. I will apply.
Mr. J.K. Goswami, the learned government advocate, appearing for which department?
Lordship,
which department?
Home, Lordship.
For the home department. 6, an accommodation to obtain the instructions in terms with the order dated 31/3/2023. So this court fixes the matter again on 22nd of May 2023, on which date Mr. Goswami, the learned government advocate, shall obtain the instructions as sought for in the order dated 31/3/2023 without fail.
Second.
Thank you.
Have you got the instruction in writing?
Yes, Lordship. But yes.
What is the instruction?
Lordship, first of all, a criminal case is pending, Lordship. And preliminary inquiry was done, Lordship. But
After passing of this honorable court's order on 21st of April, now on 24th of April, they have issued some statement of allegation.
I am saying
You've got it?
Yes.
Yes. Only 24th they have issued.
Very well.
After about four
See,
months.
at least something has happened.
And we have also already replied.
Huh?
I have also already replied.
So,
because I do not know anything about all these things. Only on the basis of the audio clip.
Look, but in paragraphs 11 in the writ petition, Lordship, the petitioner categorically stated that there is no criminal case pending against him, Lordship. But so far in my instruction, Lordship, in para 11 in my instruction, Lordship, it is stated that a case is pending, Lordship.
I don't know what is
Silabata PS case number
Yes, Lordship.
299/19 under section 13(1) A and B under the Prevention of Corruption Act is going against the petition.
Yes, Lordship.
I do not know.
Oh, one day you will be arrested, then you will know. But why have you suspended in 2022 if the case is pending in 19? Or is it in respect to some other case?
This is different case.
Huh?
That matter, my lord, that already been resolved, my lord, and some punishment was inflicted, increment, my lord. That different case. How this case can be attacked with this present case?
Have they mentioned in your that memorandum of charge about this case?
No, about this case, my lord, here.
Have you got the memorandum of charge?
Only yesterday I have got.
Anyways, have a look at. And you have submitted a reply?
Yes.
So how do you apply Ajay Chaudhary now?
No, within the period of 3 months, my lord.
That is okay, but what do you say about paragraph 22 about Ajay Chaudhary? It categorically says that now, as the petitioner has been given a copy of the memorandum of charge, that after 6-7 years, this shall not apply.
Yes.
What is this draft charges business, Mr. Goswami? There will have the wording has to be definitive charges.
Lordship, for perusal of paragraph 13 in my instruction, Lordship, it appears that conduct the primary inquiry before draft charge. It means preparing the definite charge, Lordship.
Statement of the same. The statement of allegation is here, 24. That your name is mentioned in the audio clip where it has been stated that a monetary gratification has been given to certain staff in the so-and-so. Prima facie indicates that you are involved in corruption. You are therefore implicated in corrupt practices in charge of your duties as a. Based on the evidence garnered from the audio clip, the following statement of allegation is drawn against you. You are indulged in so you have tarnished the image. You are therefore required to show cause under Rule 9. So this is the memorandum of charge you are giving.
Yes.
What else is required? This is the statement of allegations. You have submitted your reply.
Yes, I have submitted reply.
So what remains now, Mr. What can I do? Nothing remains. In view of paragraph 22.
Here in para 21 is also there.
21 is there. See 22.
22, my lord.
That is the most important thing. 22.
Para 22, I have seen, my lord. So far as the facts of the present case are concerned, my lord, maybe, my lord, after the prior to 3 months, it may be.
No, see there. No, this is after 6 years.
So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, and therefore his direction may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action to of the respondent will be subject to the judicial review. My lord, since in another case, my lord, on the basis of this Ajay Kumar Chaudhary, our High Court also passed the order, my lord. That is in Purukasta's case, my lord. Here they have said that this Honorable Court has said that insofar as the so-cause notice dated 11/4/18 is concerned, I do not find any cause and ground to interfere with the same. More so when the petitioner counsel has submitted that his client is ready and willing to face the departmental proceeding, provided he is given a fair opportunity to defend his case. His interest. In view of that, what has been told above, the respondent is directed to reinstate the petitioner in service with immediate effect.
But has the court taken into consideration paragraph 22?
Yes,
no.
That has been, my lord, already decided in the canon of decision, my lord.
No.
Lordship kindly have it.
Paragraph 22 has not been taken into account. And if it has been taken into account, this court, obviously, because that was the case after 6 years, this has happened.
This is also, here also charge sheet was submitted.
Maybe, but if the charge sheet has been given, then you see the basic idea behind Ajay Chaudhary is you have to be fast, you have to be more prompt. You can't keep a person pending out there just without issuing anything.
And, subsequent to that, my lord, I will produce some other judgment, my lord. This is there.
No, paragraph 22 has not been taken into consideration. Sorry.
Here also reinstatement has
See,
been
paragraph 21 has been taken. Paragraph 22 has not been taken. And this is the basic reason. This is the heart and soul of the judgment. That you have to do it fast. And once it has been done, then obviously nothing remains.
And since this our office memorandum of the government of Assam, that also clearly says that if it is not done within the period of 3 months,
then what happens? You are mentioning about the office memorandum dated 4/2/2020. That is by the chief secretary.
Yes.
Wherein it says that you have to review and all these things.
Yes.
But does it say that you have to reinstate if you don't do it within 3 months?
Yes.
What does it say?
Yes, my lord. I'm just reading. The second paragraph. It is therefore directed that all the senior. No, I'm reading from first. Honorable High Court Guwahati in its order dated 30/11/17. In series of writ petitions, the lead case being WPC number 6465/2017 has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India case to the effect that the disciplinary authorities are to strictly comply with the requirement to issue the memorandum charges charge sheet before the expiry of the 3 months from the date of issuance of the order.
What will happen if it is not done?
Lord, I'm coming. It is therefore directed that all the senior most secretaries of the all departments shall ensure that the memorandum of the charge sheet is served on the delinquent officer employee before the expiry of the 3 months of period from the date of issue of order of suspension. They shall also ensure that the currency of suspension order should not extend beyond 3 months if within this period of memorandum of charges or charge sheet is not served on the delinquent officer or employee.
Then?
If the memorandum of charge or charge sheet is served within 3 months of suspension, a revision order must be passed.
That is the second part of Ajay Chaudhary.
for the extension of the suspension wherever necessary. The officer proposing for suspension shall also ensure that the charges are framed and submitted to the disciplinary authority within 2 weeks from the date of passing the order of suspension. After issuance of memorandum charge or charge sheet, the senior most secretary shall undertake a review within 6 months as regards the disciplinary desirability to further continue with
Mr.
the
Chetri, this office memorandum, I know it by heart. Even I can say from here without looking into it, in the last paragraph, it has been mentioned that every 3 months you have to give this report. Isn't it the last paragraph?
all the departments shall submit quarterly return to the personnel B department with details about the suspension order issued, memorandum of charges or charge sheet served upon the delinquent officer or employee. And if any extension of suspension period is given, etc., the personnel department will compile the reports received from all departments and place before the undersigned for a periodical review every 3 months of the last 3 months suspension order for further necessary action. No such.
I remember everything about this. You see, the thing is, paragraph 22, most of the courts have not taken into consideration. Because the basic idea, you see, normally, you can very well challenge a suspension order. That is why it says, if you agree by a continuous suspension, any other ground you can do. There's no quarrel with that. That it is arbitrary, it is illegal, or whatever may be. But in a case where, if you are only on the page question that it is within 3 months, it has not been given, but it has now been given, then you can't help it.
No, since OM is very clear. Well, to that extent, I also.
Does the OM, or can this court, on the basis of that OM, hold that this thing is bad? The suspension is bad? No. This is what they have done in pursuance to an order being passed by this court. Tomorrow I pass an order, they will do the same.
That we follow my OM method.
OM is a circular to be followed by the officials.
Yes, officials and employees.
And if the officials follow it, and in following it's more like a circular. Now, once the officials follow it, then in that case, if there is a discrimination or an arbitrariness between one person to the other, this court can therefore interfere out there that, look here, in respect to them, you are giving and not to here. That is on the aspect, but not on the enforcing an OM. OM is not a law.
Whatever Lordship has thinking about this para 22, my lord, I will look into the matter, my lord. Somewhere, my lord, maybe.
Chalo.
Yes.
Well,
somewhere it may be.
After 6 months?
As your lordship.
Huh?
No, my lord.
When do you want it?
As your lordship, please.
Ms. Bleacher, the learned counsel appearing on behalf of the petitioner, Mr. J.K. Goswami appears on behalf of the
my lord, any criminal case may be supplied to me, my lord.
respondent number 2, 3, and 4. And Mr. S. Doctor appears for the respondent number 1. The learned counsel appearing on behalf of the respondent number 2, 3, and 4 had submitted that on 24/4/2023, the memorandum of charge have already been served upon the petitioner, and in pursuance thereto, the petitioner had served upon the Mr. B. Chetri, the learned counsel for the petitioner, submits that in pursuance to the memorandum of charge, the petitioner have also submitted its reply. However, it is the submission of Mr. B. Chetri, the learned counsel appearing on behalf of the petitioner, that as the memorandum of charge have been submitted pursuant to 3 months from the date of the suspension of the order, suspension of the petitioner, it is in conflict with the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus the Union of India, reported in 2000 so and so, as well as the office memorandum dated 4/2/2020, which have been issued pursuant to an order passed by this court. This court specifically pointed out to the learned counsel appearing on behalf of the petitioner, as regards paragraph number 22 of the judgment in the case of Ajay Kumar Chaudhary Supra, wherein it has been categorically mentioned that in view of the fact that during the pendency of the petition, pendency of the proceedings before the Supreme Court, the memorandum of charge has already been served upon the petitioner therein. The benefit, the declaration of law as laid given in paragraph number 21 of the said judgment shall not apply. The learned counsel for the petitioner submits that he would look into the said aspect of the matter. So accordingly, let the matter be listed again on when?
As a lord.
No, you
No, like again something. As a lordship.
tell me when.
After 2 weeks.
Okay, we'll have it on 17th of May. 17th of May. In the meantime, the respondent will be at liberty to appoint shall take necessary steps for appointment of the inquiry officer in terms with Rule 9.4 and 9.5 of the Assam Service Discipline and Appeal Rules 19. Yes, Mr. Monto, what was your case?
And deemed suspension.
Huh?
Because I was arrested as deemed suspension 6-2. No, my lord. Departmental posting, no.
Which department?
Forest.
Review is not been done. Review has not been done, Lord.
Review? You have not given the memorandum where the review comes.
Activity is yet to be done.
We'll have it on 2nd.
My lord.
I will have it on 3rd at 2 p.m.
Third.
Mr. T.J. Monto, the learned senior counsel, assisted by Mr. P.P. Dutta and Mr. S.M. Hassan, the learned counsel, appearing on behalf of the Forest Department. Let the matter be taken up again on 3rd of May at 2 p.m.
Lordship, item 42 series, Lordship, that was listed by submission of application, Lordship, next week.
What?
Item 42 series.
42?
Yes, Lordship. Analogous cases that we are looking. 42, my lord.
Which one? Regarding?
My lord, this is contempt, my lord. The Honorable Court directed to pay, my lord, arrears salary, my lord. When there was there since 2019, my lord. The respondents are taking time, my lord, on
It's a contempt matter.
Yes, Lordship. My lord, it may be listed next week, Lordship. It matter. It was for instruction whether the order was complied or not.
To me. Why these contempt matters are before this court?
My lord, this is a best three matter. Lord.
There is an order pass.
Yes,
Who is
Lord.
appearing for the respondents?
Mr. B. Gogoi, Lordship.
Huh?
Mr. B. Gogoi, Lordship.
B. Gogoi.
Yes, Lord.
Okay.
My lord,
What are these orders? Let's see. Last order. Due to paucity of time, matter could not be taken up. They stated the factual demand the claim of the petitioner for minimum wages of 9 pounds is on. We have noticed that this batch of AR involves multiple petitions. Accordingly, 4 further weeks is budgeted to complete the necessary verification that is required. You have asked for which order? Compliance of?
My lord, page 63 kindly is in Lordship. Paragraph 19.
Where?
Paragraph 19, page 63. Okay.
WPC number, Imam.
Terms of the order. Lord. Page 63, my lord, in contempt.
According the respondents are directed to pay the area honorarium to the female attendants, the minimum wage at rupees 900 per month from the date of their engagement to 39 to the. What was your date of engagement?
Engagement in 1981, thereafter, my lord, different dates are there, Lord.
So this order was passed when?
In 2017, Lord.
And till now it has not been complied with.
In the meantime, many of them will have.
Which department we are concerned?
My lord, health and family welfare. Lord.
Well, no health and family welfare department council. It is secretary to government of India.
My lord, mainly, Lordship, it was a formal party, Lordship. Now the health department of Assam, my lord, health and family welfare department.
Direction was given to whom? The state government?
Yes, Lordship. Respondent, Lordship. My lord, state government was undertook, my lord, to pay lordship. Several orders are there, lordship.
Directed to pay the area honorarium to female attendant. The minimum wages at the rate of 900 rupees per month from the date of their 390,000. Okay. All the matters you are there. Your matter.
My lord,
In all the petitions you are representing.
accept, my lord, accept item number, that is item number 49, my lord. Up to item number 50, my lord, I am in there, lord. 42,
Mr. Your name?
M.H. Ahmed.
M.H. Ahmed, the learned counsel appearing on behalf of the contempt petitioners, submits that the order dated 23/10/2017 passed in the various petitions have not been complied with till date. None appears on behalf of the contemners on call. It is also apparent that they have not filed affidavits.
My lord, in some cases, file affidavit, lordship, not disputed, lordship. My lord, time was taken to comply with lordship order.
Then why
My
they have
lord,
not complied with?
There are series of orders in the item number 42, lordship.
Where is the item number 42? This is the 42.
Yes, lordship. Item number series of orders. Kindly see in lordship item number order dated 17/3/2021, lordship.
Government has, the government has no money.
My lord, money is there. All things are going on, but the meager
Government has no money. Does it look that way? Otherwise.
Otherwise, lordship. Since 2021, in the name of budget, lordship, my lord, nothing is, many budget sessions have gone, lordship. 17/3/2021, my lord. Last chance was given, lordship, to comply.
None appears on behalf of the contemners on call. The learned counsel for the petitioner has, however, submitted. Yes, Mr. B. Gogoi. I was supposed to call these contemners.
My lord, the budget proposal was submitted, my lord.
Understood, but this is the order of 2017. Does it look nice? When do we expect it to be complied with?
I understand, my lord.
When?
My amount is too big, my lord, to say.
What is the amount?
It's, my lord, some 4,200 crores or so.
Huh?
4,200 crores or so.
4,200 crores?
Yes, my lord. I have an my lord, on the last occasion, it was, my lord, it was at around 70 crores loss. For 70 crores? Yes. My lord.
70 crores is peanuts for this government.
Sorry.
You have multiplied it by 600 times.
So, sometime, my lord, it was placed before the budget.
Understood, but does it take, how many budgets have gone 2017 onwards? 17, 18, 19,
No,
20, 21, 22.
Verification to, my lord.
Huh?
There was an order for verification only thereafter, my lord.
Understood, the verification can it take for 6 years after an order?
I understand, my lord.
Verification is only as regards the period, if I am not wrong. It is not on the quantum. The period will show the quantum. Now, have you verified it?
That part is over, my lord. So, my lord, they could figure out what will be the amount.
So, what is the amount?
That, my lord, already perhaps it is recorded in a course order, my lord. Earlier.
Where is it?
My lord, in order dated 17/3/2021, lord.
17/3/2021.
Lordship. Elaborate order is here, Lordship. And last chance was given to comply, Lordship. Thereafter also, my Lord, several
17/3/2021.
times.
Yes,
on this.
insofar as the financial implication of about the projected extent of financial would not be an impediment for the court to enforce compliance. Okay, now with concern to the Iman has not been given one last opportunity is granted to take appropriate steps, failing which. Now this was given in 2021. Why haven't you put it in the budget?
It was placed, my Lord.
Then they don't want to.
To my knowledge, my Lord, it was not sanctioned, my Lord. No place. From the director.
Are you saying an order being passed by this court, the budget having been placed, then it has not been sanctioned?
And that is what the
So who has not sanctioned it? We make him a
from the
party.
Government and my Lord.
Government in which department?
Health and my Lord, it will be placed before the finance for the approval.
Fantastic. So we make the finance whom? The commissioner and secretary as a
Well,
party.
let it be, my Lord, next week, my Lord, whatever is
We'll have it on 3rd.
on Wednesday, my Lord.
That
Yes,
is
third,
Wednesday is 3rd.
Third.
So, Hili last line too. It, however, appears from the order dated 17/3/2021 that this court had given a final opportunity to the respondents to comply with the directions given in the order dated 23/10/2017. 2 years have passed by since then, but till date, nothing has happened. On a this court had put a specific question upon Mr. B. Gogoi, representing the contemptors, as to why the orders passed by this court, the judgment and order dated 23/10/2017, in spite of the order dated 17/3/2021, has not been complied with. The Learned Counsel submits, as per his instruction, that the budget has been placed. Proposal in the budget has been placed, but however, the same has not been sanctioned. This court would further hear the matter again on 3rd of May 2023 as to why and which are the departments which are responsible, which led to the non-sanctioning of the said amount, taking into account that there is a judicial order passed by this court and there has been nothing, there has been no compliance to the same for the last 6 years.
It will be listed as fixed matter at 2 Lordship, 2 p.m.
Don't worry, I'll look into it.
Yes, Lord.
I am appearing for item number 14.